বলতে গিয়ে দেখবেন না সামনে চশমা রাখে। Satisfied?
My lord, I am mentioning one state tribunal matter for hearing. This is a very old matter, my lord,
Not
2013.
before the vacation. Only the motions, you know, you are a veteran in the profession. Before the vacation, only here the
Yes,
motions.
okay.
I'm not. I have a stay application, but which was returnable yesterday. My lord, so not made. It was not made appear on
Come
Monday.
tomorrow.
My lord, Monday. My lord, made appear
Come
on Monday.
tomorrow.
Tomorrow. My lord, I have no difficulty. My lord, the council. My lord, I don't know whether Mr. Monday. My lord, could it
talk
appear
to
on
them.
Monday? My lord,
If they come tomorrow, we are sitting. Don't worry.
My lord, could it appear on Monday? My lord,
No, not tomorrow. Tomorrow. Come.
Lordship makes it Monday. My lord.
Where is the difficulty? We are sitting tomorrow. The
Lord, I'll
court
inform the
is,
councils. Lord, when Mr. Hon'ble is happy, but I inform. But Lord, kindly
Tell him.
let
I tell him.
Lord may this appear not on Monday. Lord,
It is a commercial matter.
I'm grateful to Lordship.
Commercial matter.
Yes, commercial matter, but it was. I'm grateful to Lordship.
Your Lordship's kind leave to mention, my lord, item number 198 of your Lordship's combined monthly list.
What is this?
Well, it is a appeal arising out of an order passed by the LRTT.
hearing.
No, man, not hearing. Not hearing. It's at the motion stage.
Motion will consider whole week. We will take up. Don't worry.
Very well.
Don't worry. We'll take up the motion whole week. Yes.
I mentioned 262 of the district motion combined list. 262.
Eight, we will be taking motions. We will not take one matter from commercial side. Don't worry. Every day we'll take a motion.
Item number 73 of the last item today's list. Interim order expiring today. I'm giving notice to Mr. Solicitor General.
Just wait. If we cannot reach, we will definitely.
Lord, we leave
My lord, do we have
Just
to?
remind when we are rising.
I have a prayer. This is a complicated matter.
Come on Saturday, then do the matter.
Both of us have agreed, kindly fix it up on next Wednesday. Because today is a contempt matter, kindly extend the.
No, it's a, I tell you, Mr. ASG, if there is a contested matter, you see just 4 or 5 days are left. So all the motions we will definitely take. Where an urgency for an interim orders are there, we'll definitely.
Then your losses kindly extend the interim order till 1 week after vacation.
Let us see, come, if you just remind me at the time of rising.
Lordship, I'm mentioning FMAT 40 of 2022. The order was pronounced on 20th April 2022, but it's yet to be uploaded. Your Lordship, there is urgency.
It will be uploaded, don't worry.
There is urgency in the matter, Lordship.
Yes, I have seen that it is loaded.
The direction to get the MOU registered.
Please, it will be loaded, don't worry. Today itself, you will get
Lord,
it. Don't get-
Your Lordships had heard, Lord, Mr. Mukherjee, Lord, has concluded the submission. With
Which one?
respect to Lord West Bengal Estate Acquisition Act, wasting for application of
not
4B2.
hearing, we will not-
Lord, it's over. Your Lordship's hearing is concluded.
we will deliver
Lord, the
the
other side had filed their written notes of submissions. Lord, may we file your Lordship's kind assistance, Lord?
Lord, with leave of justice, Vishwas, Lord, I am mentioning one matter, Lord. But again, contempt first time matter, Lord.
Written notes of
Lord is sitting with me, on justice, Sampad Datta Pal. Let it,
after it.
Well,
Don't come before.
Well, item number.
let it appear after vacation.
It will appear, don't worry. Just wait. Just go.
If I not.
What?
I ordered presentation, I will small submission to Senate. I am Vinod Gupta, my lord. I am a senior classical registered officer with the Government of India, Ministry of Defence. At WPCT 64.
You have engaged a lawyer?
The Ministry of Law is not engaging. They are saying Ministry of Law is saying just kindly bring a copy of WPCT. And the copy of WPCT has not been served upon the Union of India.
Maybe we'll consider when the matter will come. If it is
My
not,
lord, item number 193, WPLRT motion, my lord, order, my lord.
we'll take up the.
My lord, by Monday, my lord, my junior, my lord, submitted, my lord, urgency slip, my lord, till
We
date, my
will-
lord.
We have considered it. We have not found any urgency. We have rejected it.
Obliged.
My lord, kindly allowed.
No, that we can't do it unless the matter is taken up. Yes. Call. What is this?
I thought this is my application.
What,
Your Lord.
sir, Lordship, I just came late, Lordship.
What?
Mentioning of 5 matters which are related to the 10C.
I just had a talk. We will list all the matters after the vacation. Don't worry.
Lordship.
Your Lordship, there is a direction upon me to serve on the National Health Authority. I have served, Your Lordship.
What is this? What is this application?
Your lordship, this is an application against the stay, your lordship, an order passed by the district judge. The question, your lordship, is I have not been served upon the order from the arbitrator under section 31(5). I have received an order through RTI, your lordship. Now the district judge, the court below, has rejected my plea on the ground of limitation.
Where is the survey? Show
Yes, sir.
us. Service. Which for the other side? There is no question of any stay to be granted. The
Sure.
Section 34 has been dismissed. We have to hear out the appeal. Nothing more than that.
I have served your lordship. If your lordship directs me, I can serve again and come back.
Whatever, not necessary. The appeal is admitted. The appeal is admitted. After perusing the nature of the impugned order and upon hearing the counsel for the appellant petitioner, we do not find any grounds warranting an interim order to be passed at this stage. Let the appeal be let the hearing of the appeal be expedited. The appellant is directed to file an informal paper book type cyclostyle Xerox within 2 weeks after the reopening of this court following the summer vacation. The petitioner is the appellant petitioner is also directed to put in the requisites for effecting the service of notice of appeal upon the respondents in course of this within 7 days from date. So office is directed to effect the service immediately. Liberty is granted to mention for enlisting of the instant appeal upon after the service has been effected upon the respondents.
Your lordship, same matter, your lordship, or the service has been done.
He has misconstrued the provision of section 14 of the Limitation Act. What can be done? Same order. Section 14 like order. Was prosecuting with due diligence on the advice in a wrong forum, another forum. Section 14A apply to. Section 5 does not apply to suit.
My lord, I am for the opposite party.
That I appear for the applicant, Union of India. This is an application for restoration.
I am for the opposite party, my lord.
When
I leave to your lordship with a prayer, my lord, kindly hear the matter as my client, the opposite party herein, retired since long and he is not getting any pensionary benefit.
no, the matter is dismissed, why the pensionary benefit is not given?
The suspension order was passed by the railway authorities.
Now he has retired.
Now he has retired, my lord.
And what happened to a disciplinary proceeding?
My lord, that is pending. I filed a revisional application.
They're still pending.
Yes, my lord, that is pending.
Any pecuniary loss, any kind of the thing, no.
My lord, kindly see the moment of the landed Central Administrative Tribunal's order, my lord, in the main petition.
Now, let it be restored, my lord. I shall make my submissions on the points of merit in the matter.
This is an application for restoration of the writ petition which was dismissed for default on 8/11/2019. So after perusing the amendments made in the instant application and upon hearing the respective counsels, we are satisfied that the petitioner was prevented by sufficient cause in not appearing on the said fateful day. So the application is thus allowed. The writ petition is restored to its original file and number. Let the writ petition be listed. WPCT on 12th June.
I am grateful to you.
Much obliged.
under the heading motion, এটা motionই ছিল।
My lord, item number 8, I am for the petitioner, my lord. My lord, at first I want to not place the CAN application number 1, CAN application number 1, because the CAN application is the application for substitution, but it will not be the application for substitution as the respondent number 7 has been died before the institution, before the filing of the writ petition. The writ petition was filed in the year 2022, but the respondent number 7 has been died in the year 2017. But no respondent has been informed us regarding the death of the respondent number 7 before the learned tribunal. As
Want to withdraw? Withdraw.
no, I want to not press the application.
Yes.
And now I am proceeding before the CAN 2. I am moving before the application for CAN 2, and this is
Learned advocate
for the
appearing for
addition of the
petitioner.
parties, my lord.
The learned advocate appearing for the petitioner submits that his client does not intend to press CA and CAN 1 of 2022. So in view of the above, the CAN 1 of 2022 is dismissed as not pressed.
Now, my lord, I am moving the CAN 2 application. This is the application for addition of parties, my lord, because the legal respondent number 7 died in the year 2017, and thereafter the legal heirs of the respondent number 7 has to
Don't exhaust your energy.
no, has to be impleted. This is the affidavit
Why
of
don't
service.
you give a copy?
Affidavit of service.
Sir, when a counsel is appearing, why don't you give him a copy?
I've given the service.
Really?
I've given. This is my affidavit of service.
Oh, too technical.
Oh, so no, sir. I'm giving the copy right now. I'm giving
Give.
the
Then why you are saying all these things?
one copy. One copy. This is your copy. See,
Can choose. This is an this is an application. Where is the judgment of the Supreme Court?
So, my lord,
Where is the judgment of the Supreme Court?
judgment of the impugned order, my lord.
Re-
Supreme Court judgment. No, sir, there is no judgment, my lord.
Why addition?
Because the respondent number 7 is a party in the suit. Respondent number 7.
He died
He died in the year.
prior. You filed a proceeding
Because
against a person,
he,
against a dead person. Why not? Why not the proceeding should go?
because my lord, no respondent number 9, nobody has informed us regarding the death of the.
That is
and
a different, that is
and
a different
ultimate-
scenario. That's how addition will come.
And I'll
Proceeding against a dead person.
and because I have come to know, because this is my lord's order. Kindly
Show us the judgment, show us the authority that the addition is permissible when a proceeding is filed against a dead person.
Because my lord, I am submitting before your lordship that the
A 47 CW and ESO ওনাকে দিয়ে দাও যে proceeding must go.
no, my lord, just a minute, my lord. I'm
Nullity.
no,
A proceeding against a dead person is a nullity.
no, because my lord, I have come to know before that.
Why addition?
Why addition? Because I have to respondent number 7 is a party and he is sojourn. He is a party in the suit. He is a sojourn. Yeah, I have to. He is sojourn, and that's why his legal heirs.
Is an addition.
Now his legal heirs has to be added, has to be included.
And what happened? That he remains on record, a dead person.
Yeah,
Dead person remained on record. Will the proceeding
and that's
continue?
by expunging the name of the dead person.
Expunging when? Under what provision you can expunge the name?
Because I have to add by the order 1 rule 10(2) for the addition of parties.
Does it talk about the expunsion or expunging the name? Or it comes under order 22, rule 5?
Because
Tell me.
my lord, kindly see the order of my lord. I have come to the 19/9/2022. I have came to know regarding the death of the respondent number 7.
I'm not saying, sir, these are all merit. I am saying the maintainability. Whether an application for addition, bringing the heirs and legal representative of a deceased respondent by way of an addition. Because the proceeding itself is bad, having filed against a dead person. You know, 1954 Supreme Court Kiran Singh's judgment. It's a nullity. Any order which is passed is a nullity.
Because my lord, I have no knowledge, man. I'm totally ignorant regarding the date of
The law would be different because you had no knowledge, so it will be a different one. The law would be different when you had a knowledge.
whenever I came,
Both the cases,
Huh?
tell me addition. Sure.
whenever I came to the knowledge, then and then in 24/1/2023, I filed the addition of for this
And
an
we are laying
application.
down the law that knowledge will not be a factor. We are dismissing. We are dismissing.
My lord, I'm praying for time. I don't have.
When the court, sir, is it not your duty that when you draft the petition,
Hmm.
then you will first ascertain whether this petition can be maintainable in such situation? Will you not, is it not a duty of the lawyer to first ascertain whether this course is permissible in law? We expect that. When you are coming and saying something, then at least you must be sure, even a doubly sure, that what you are doing is correct. And you have to justify that. Mere eloquence will not do. और खाताটা কি বল? এই দেখো তো এখানে 2006 or 8 SCC আছে এখানে দেখো। আগের দিন একটা ডেকেছি দেখো আছে এখানে। একটা 2009 CHN ছিল। একসঙ্গে দুটো বই আনা হয়েছে। হতে পারে তার সঙ্গেই ছিল 2000 এর সুপ্রিম কোর্ট দেখি। Read paragraph 19. It's a federal court. I was just talking about 47 CWA. Read paragraph 19 loudly.
Paragraph 19. Paragraph 19. Yes.
Read loudly.
In Bank of Commercial Limited, Khulna versus Pratap Chandra Ghosh and others reported in 1946 FCR 32, a dead person was impleaded. A dead person impleaded as respondent in the appeal before the Federal Court of India. There was an application or to bring his legal representative on record. The Federal Court of India holds the present case obviously does not come under the first category because Amol Krishna was not in the eye of the law a party to the appeal as originally preferred, as he had died before the date of filing of the appeal. The addition of parties referred to in the rule cannot cover the representative of death, representative of a party in whose favor a decree had been passed by the lower court, because in such case a proper court will be to prefer an appeal against him and not merely add him as party to an appeal that had already been preferred against the other parties. That this was the intention of the rule is shown by the fact that the reference in the same rule to section 5 of the Limitation Act is limited to application to bring the legal representative of a deceased party on the record. Rule 7 also shows that the addition spoken in the Rule 6 refer to an addition necessitability by a party already on the record undergoing the change of statutes, where an appeal has been preferred for the first time against the heirs of the person in whose favor the lower court had passed a decree. The mere fact that an appeal had already been preferred as against the other person will not justify the application being treated merely as one to add a party. Even if it is to be informed, it is in substance an appeal preferred against him for the first time, and it is only on the footing of the question of the application of section 5 of the Limitation Act as such case will arise.
What it says against you, sir? No addition. No addition, sir. This is a Calcutta High Court judgment.
Calcutta High Court
No,
judgment.
no addition. Then I told you, tell us.
Yes.
You do not care to read.
I
Luckily, this judgment was here on the page.
had no knowledge
No knowledge.
regarding this
And then you
judgment, my
started
lord.
arguing.
I had no knowledge regarding this
And
argument.
then you started arguing.
No knowledge regarding.
And you not press the first one immediately so boldly and then say second. I am pressing application. Now second is barred by virtue of this judgment. What can we do? Now tell us.
In my lord, we have
2000 pounding. तो ये सौ भी इस चीज़
line one clearly. The 2009 one CLJ Cal. From a 19. 19. No, my lord.
Let us be saying, the law is very clear. I have given you a judgment of our High Court. What is the view on a basis of a federal court judgment?
Then, my lord, I have to.
Then what?
Then
what? Tell us.
Then, my lord, we have to file the substitution application. No, substitution. We
Judgment says substitution also. When the substitution arises, when a party during the during the pendency of the proceeding died. Look at the language. But he was dead before the proceeding started. So substitution, how it applies? Yes.
হ্যাঁ একটু জাজমেন্ট দেখেছি। Almost 168. State of Kerala.
State of Kerala. नीचे जाओ. नीचे जाओ. Read paragraph 5.
There was no need to invoke any of the rules of order 42, order
42.
22, sorry, order 22, as there was no question of abatement since date of the sole respondent had taken place only after the judgment was delivered by the sub-court. The error which had crept in the crept in is that the appeal has filed against person who was not then alive. In such a case, order 1 rule 10 has to be invoked. There was no specific period of limitation for making the application in the appropriate rule, and hence
Doesn't know anything. This judgment supports your contention and you don't know. You will never read the judgment of the Supreme Court.
within 3 years after Article 137 of the Limitation Act,
What does it say? That order 1 rule 10 will apply. Has to be invoked.
there is no specific.
In such a case, order 1 rule 10 has to be invoked. What does it mean?
That will be applicable. That order 1 rule 10 will be applicable under the limitation under Article 137 of the Limitation Act. In the present case, application.
So you have not read the judgment at all. You have not understood what is going on.
No, my lord, the order 1 rule 10 has to be invoked, and there is no specific period of limitation. There is no specific period within a specific period of limitation for making the application in the appropriate rule, and hence all application is necessary the same would be filed within 3 years under Article 137 of the Limitation Act. In the present case, the appeal was filed March, been filed on by March 93. That was fine. Article 137, Limitation Act.
This is an application seeking addition of the heirs and legal representatives of the deceased respondent number 7 in the instant writ petition. The dispute relates to the entry in the record of right, respect of the immune property, and therefore the heirs and successors and therefore as a right to, and Therefore, the heirs and successors have a right to pursue the claim of the deceased as right to sue survives with them. Admittedly, the respondent number 7 died prior to filing of the instant writ petition before this court. The said respondent number 7 has been arraigned as a party
2017.
prior to, I said prior to, sir, why? Yes, prior to such as that, then second sentence, he can't take a point. He can't take. As has been arraigned as a party in the instant writ petition, though he or she
She, my lord, she.
though she died prior to the institution of the present writ petition. The apex court in case of the state of Kerala, what is this? Where it is gone? नीचे करो. Yes.
State of Kerala, but
The apex court in case of state of Kerala versus Sri Devi, others, reported in 2000 volume 9 SCC page 168, held that in the event a dead person had been arraigned as a party in an appeal, the proper mode to bring the heirs and legal representatives is by way of an addition under Order 1, Rule 10 of the Code of Civil Procedure. In view of the law enunciated in the above report, we do not find any ground warranting the refusal to accept to grant the reliefs claimed in the instant writ petition. Accordingly, the application is allowed. The person named in paragraph 5
yes, my lord.
of the instant application be added as party respondent in the instant writ petition. Since the respondent number 7 is dead, his name is a strike off from the category of the respondent in exercise of power conferred upon the court under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure. The petitioner is directed to amend the cost title. The department is directed to amend the cost title on the basis of the observations made here in our.
My lord, grateful, my lord. I have learned lot of things from you, my lord. I am very much grateful to you, my lord. I have learned lot of things from.
The High Court judgment did not notice this judgment.
I am very much grateful to you, my lord. I have learned lot of things from you, my lord. I am very much grateful to you, my lord. I had no
Duty to first ascertain before you take any steps.
I had no knowledge.
It is only the court who has to find a judgment for you.
I am very much obliged and grateful to you, my lord. Very much obliged and grateful.
Next.
Grateful, my lord. Grateful.
It's an application for restoration and section 5 also is also there.
It has already been allowed.
But that's a restoration of restoration that your lordship was pleased to allow. And
no cost was imposed.
we were considering the age and health condition of the advocate on record. Your lordship was pleased not to impose that.
And now where is that original application?
Yes, but the Can 1. Can 1 is the original restoration application.
How can it be? Can 1?
Yes. Can 2 is section continuation of delay. Can 1 is restoration, and Can 3 that your lordship was pleased to allow. সেটা তো ডিসপোজ অফ হয়ে গেছে আগে দিচ্ছি সেটাই বলে দিচ্ছি by order dated 16th of December that was dismissed for default. Page 5, paragraph 2 is the explanation mark of can 1.
Paragraph 2. She was under the impression 3-4 as someone what we call a proper instruction. This is the ground for giving it's a ground for sorry 2 is ground for divorce 3 to 4 is a ground for divorce. Actually ever delay is CN2.
Yes, madam.
Can 2 is a application for condonation. आगे लिखे ना section 5 टा आगे लिखे ना can 1 is restoration. Delay in filing can 1 it application 5.
It is submitted on behalf of the petitioner that the ground as assigned in paragraph number
345 rate करो
that it is
we have it appears from the that we have a curriculum.
it is
What is submitted there?
it appears from the amendments as made out in paragraph number 3, 4, and 5 that the learned advocate on record was under impression that the matter has been out of list due to non-appearance of non-appearance of anybody on behalf of the petitioners on the fateful date. Stop. It is further submitted that the after obtaining certified copy of the order, he came to know that about the aforesaid order. Stop. It has further been stated that the learned advocate on record informed through phone of the aforesaid order dated 16/12/2022 to the petitioner, and thereafter he files this instant application for restoration for condonation of details
And condonation.
We find that the grounds assigned in paragraph number 3, 4, and 5 are satisfactory, and so we find there is no impediment to allow the petition. Accordingly,
And therefore the delay in filing an application
the
for
delay-
restoration is
condoned.
controlled. তারপর restoration টা নিয়ে can 1 হচ্ছে শুধু paragraph 3 it corrects the body.
It is further been stated. It appears from the
paragraph 2 টা
Sorry.
it appears that
it appears from the amendment as made out in paragraph number 2 that
the advocate of the court
the advocate on record failed to come to court on the date of hearing due to the illness of his wife, and accordingly, at the time of calling of the matter, none could not appear on behalf of the petitioner before this court, and as a result, the instant
the writ petition was dismissed
petition was dismissed
for default.
for default. Yeah, I find that the ground assigned in paragraph number 5 is satisfactory, and there is no impediment to allow the petition. And accordingly, petition restored.
The application for restoration is allowed, the writ petition is restored to its original file. ওখানে আই বলে দিয়েছেন ওকে বল বি করো আমারও হতো সিঙ্গেল বেঞ্চে বসে বসে তারপর ডিভিশন হচ্ছে
Extremely good.
a writ petition be listed 2 weeks after the vacation.
Extremely grateful, my lord.
In this matter, Lordship, I beg to appear on. In this matter, Lordship, I beg to appear on behalf of the respondent.
What is this?
My lord, the one CAN application has been filed, my lord, on behalf of the department as per instruction of the department, my lord. Only 10 days delay, my lord.
What?
10 days delay there was, my lord, as per.
Can 1 was
That's a
dismissed. Now can 1 is restored.
Can.
Now what is can 1? Continuation of delay for what?
Filing of writ petition, my lord.
Is there any period of limitation for
No.
filing the writ petition?
My lord, as per instruction, my lord.
Yes.
As per instruction, department, my lord, says, my lord, to file the 6 and 5, my lord.
With department. So you will learn the law from the department or you will learn law from your own? Or from reading the statute, from reading the statutory book? How you will learn the law? Tell me, is there any period of limitation provided for filing a writ petition? I am asking.
Oh, I can. Tender
Under the
my lord,
Limitation Act, nothing.
apology.
Then,
I tender apology, my lord.
then why section 5?
I tender apology, my lord.
Yes, delay and laches can be one of the ground where the court may refuse, but you can explain it in the writ petition itself. Why condonation application?
Tender apology, my lord. I tender apology, my lord,
What?
for filing the application, my lord, 6 and 5.
Please?
Kindly take up this matter after vacations, or we shall address it on behalf of the
It's not
petitioner.
a suffering, Lordship.
So-
From November 2022, this matter is appearing in the list fairly at the top. Either they pray for adjournment or fail to appear. Ultimately got dismissed for default and.
Madam,
restored.
there is no stay order.
No. Lordship,
So
since
there is
we
no
are a casual
difficulty.
worker, Lordship, we have, since we.
But
pay
I am
for
really
default-
surprised that when the submission is advanced by a junior counsel saying that department told me to file application, so I filed application.
Not,
This
it
is
should
something
not have
very
been
alarming.
submitted That way, not, however, he has done these things, not, kindly consider. So, not,
What
Not
consider?
yet, Lordship.
kindly
When the WBCT
ignore these
we
things,
heard,
will not
Lordship,
take up this matter. Kindly
We
ignore.
can't assure you.
Kindly ignore.
Since the respondents are suffering, Lordship, they are.
What for, sir?
planted
There is,
food.
madam, there is no, suppose if he has not filed the writ petition, yet you have a right. There is no stay order passed. Then why you are so apprehensive? Come. This is an can 1. This is an application seeking condonation of delay in filing the writ petition. There is no period of limitation provided for filing the writ petition under the Limitation Act. It is no doubt true that despite having not provided any specific time within which the writ petition is to be filed, the court may refuse to exercise the discretionary jurisdiction if there is a inordinate delay and the laches can be attributable to the conduct of the writ petitioner. It is an ardent duty of the writ petitioner to explain the circumstances which occasions the delay in filing the instant writ petition, and also to satisfy the court that there is no laches which can be, with the latches, which can be fastened on them. To stop. We do not conceive the procedure that an application under Section 5 of the Limitation Act is filed in relation to a writ petition under Article 226 of the Constitution of India. So the application is thus misconceived. The same is hereby dismissed. However, liberty is granted to the petitioner to file supplementary affidavit incorporating the facts occasioning the delay in filing the instant writ petition within 1 week after the reopening of this court following the summer vacation. Stop. The mere pendency of the writ petition shall not prevent the respondent in proceeding in accordance with law.
Much obliged.
It is actually a constitutional application. There cannot be for invoking the constitutional fundamental questions is always considered.
Lord, I am for the petition, my lord. This is an application for amendment, my lord.
Lord, I am appearing for the respondent number 1, my
Have you served?
Yes, yes, my lord. Lord, I have served, my lord. Lord, when this matter, my lord, came up before my lords on
Will you, what you want to, what are the proposed amendments?
my lord, in the schedule, my lord, I have mentioned page 6. My lord, some documents, my lord, not been annexed, my lord, at the time of filing of this writ petition. And to that effect, my lord, the averment was.
Those were filed in the in the tribunal?
Yes, yes. My lord, the some order passed, my lord, for that, my lord, kindly, my lord, the take up page 38. Page 38, my lord, the order passed in a OA number 96 of 2022. My lord, the learned tribunal below was pleased to, my lord, extend the time for conclusion of the disciplinary proceeding. Now, my lord, page 38, my lord, the ordering portion at page 43. Page 43, my lord, heard both the parties peruse the records. It noticed the disciplinary proceeding was initiated 2/3/2017, and the applicant earlier occasions came before this tribunal such and such with a prayer conclude the disciplinary proceedings, and this tribunal has granted 6 months time to conclude the said disciplinary.
Last chance was given to dispose of within 6 months.
Yes. Now, my lord, kindly.
Otherwise, the proceedings shall be vitiated. Then.
Now, my lord, kindly comes to page 49. Now, subsequently, original application filed, page 49. The instant, the fourth paragraph, the instant application has been filed, basically challenge the impugned departmental proceedings 2 of 2022 dated such and such, and departmental proceedings 1 of 2017 dated 2/3/2017.
Yes.
Now, my lord, kindly comes to next page. By this order, in view of the above, respondent of SP is directed before representation. The inquiry officer is also directed not to proceed further till next date of hearing. Now, my lord, this way, next date, my lord, the fixed on 22nd September 2023. This is pending interim order, my lord, extended until further order. Now, my lord, the issue is that their case in the instant petition is that the DP was not concluded within that time. So, my lord, the provisional promotion.
But your contention is that because of the interdict, means the interim order which is passed,
Lord,
you could not proceed.
I am not able to proceed. Lord, that fact was not brought into record in this my writ petition.
Okay.
Let him serve me an amended copy of the writ petition.
This is an application for amendment of the writ petition, seeking to incorporate the facts and the events, including several orders passed by the disciplinary authority as well as the tribunal. In the seeking to in the writ petition. ঠিক আছে? Incorporate in the writ petition করবো। Herein. Seeking to incorporate those facts. বাস ঠিক আছে, ওটা তো হয়ে গেছে, full stop. It is a word in the instant application that certain facts which were disclosed before the tribunal could not be incorporated while drafting the instant writ petition. And also writ petition and also the subsequent events which have material bearing at the time of disposal of the instant writ petition. After perusing the schedule of amendment, we find that those are formal in nature and necessary for the complete and effective adjudication of the disputes involved in the instant writ petition. Accordingly, the application for amendment is allowed. Let the schedule appended to the said application be incorporated in the writ petition. Stop. The petitioner is directed to file the amended writ petition within 2 weeks after the reopening of this court following the summer vacation. So the copy of the amended writ petition shall be served upon the appearing respondent on or before the returnable date. So let the writ petition be listed 3 weeks after the vacation, summer vacation.
I beg to appear for the applicants. But can one is the application for substitution of the my lord applicant.
What?
Can one is the application. Old number is my lord 7004 of 2014. Is the application
What is that? Old number is?
7004 of 2014.
Correct. What is that
Is
application?
the application for substitution of the applicant in the contempt application. Now, my lord, the second application is
Substitution of the
applicant
applicant.
in the contempt application.
Correct. And can do?
Can 2, my lord, is the application for addition of party by amendment of the cost title incorporating the name of the new incumbent. My lord, that I do not want to place. That is 2014 matter, my lord. The new incumbent has already come and your lordship pursuant to the earlier direction I have already implemented. So can 2 I am not placing. Now can 3 is the application for section 5 of that substitution application. There has been delay of my lord more or less 8 years. There has been delay in filing the substitution more or less 5 years. That is why my lord, section 5 has been filed.
Yes, what you have said. Is
My lord, I have stated
difficulty.
Paragraph 2 of the contempt,
Good ground.
paragraph 2 of
Consider
the,
it for all time to come, good ground. Yes,
my lord, in the paragraph 2 of that section 5 application, the certain thing was narrated that, my lord, after the death, my lord, the family was get crisis medically and economically.
yes, then
5 years. My lord, after the death of the father, the family, my lord, get crisis both mentally and economically. That one of the, my lord, it has been stated. And my lord, the mother was suffering from certain disease, my lord. And that has been stated, bronchoserious arthritis. My lord, that is why he could not move, my lord, on several years.
matter relates to what?
My lord,
What was the direction and why the contempt application has been taken up? Don't worry, we know how to overcome it, if he says.
My-
We can convert it as a suo motu proceedings.
my lord, recording the name of the Borgadar.
If it goes, we converted it as a suo motu and then held them liable. Tell us that what is a,
My lord, while my lord,
that we know how to do it.
my lord, the Borga recording was cancelled by the order of that honorable court with a direction to take, in view of that order, to take with a direction upon the respondent to that extent that in the view of that order, take appropriate steps. Well, that step was not taken.
The Borga recording was deleted.
Yeah.
That means they have to correct the record.
My lord, only to that extent, my
Borgada, they are
my lord,
not corrected as yet.
my
They have not corrected as yet.
not.
Tell us, sir, why you did not correct the record of this by deleting the name of the Borgada. If that is the fact, we have not opened the file as yet. If that is the fact,
The
then
order
tell
for
us.
my Lord Justice Pinaki Chandra Ghosh,
Yes.
my Lord Justice Asim Kumar Rai, my Lord, that is the WPLT.
I am simply
Which is-
asking,
from
is
which matter
this,
contempt
is this
arises, my
the
lord?
tenet of the order? Is
Madam,
this a
may I
tenet
read?
of the order? I am simply asking you this question, sir. That the Borga which recording has to be erased and then he being a riot should remain.
It is not the case, my Lord.
But he says so.
My Lord, the Porgaradar, my Lord, not submitted the any bhaktas to the landlord. Therefore, the bhaktas of the
I am not concerned with that. I am concerned with one fact. It's a contempt jurisdiction. What was the order passed by the division bench and what the violation has been done? He said that the division bench directed the deletion of the name of Borgada from
no, my Lord, it is not the correct.
to us.
My Lord, your
He has not correctly said to us. Where is the order?
Page
Main
16.
order.
Page 16. Page 16. Page 16.
16, my Lord.
Sure.
My Lord, may I read?
What is the date of the order?
Order dated
November 2006.
6.
Correct.
Now in the page 17.
That was a picture.
Where are the orders of the? Oh, let us see. Where is the order of 2nd August 2001 passed by the prescribed authority? Can you show us? We'll dispose of the matter here and now. We do not want to indulge in this. Where are those orders?
Page number 30. No. 2nd August 2001. Well, it starts from page 30 of that. Second August. Malad, it starts from page 30 of the WPLRT. কপি আছে আচ্ছা দেখে না একবার আমার কাছে কপি বুঝতে পারছি না কি অর্ডার না
Yes, where is an appeal against the order of the prescribed authority?
appeal petition. You are still asking for appeal petition.
Appeal. There is an order of 30th of July 2001.
File.
Prescribed authority has decided.
Prescribed authority 51A5 is the appellate authority.
Yes.
Yes.
Where is the appeal? Appellate court order.
That is the appellate court order. That is the appellate court's order. Vilasam, may please find in the order sheet top. LR appeal number A5. A5 is the appealable.
Is a appeal.
Appeal board.
Against that you challenge the order.
Before the tribunal.
Where is the order of the tribunal?
Tribunal. Page malad. No.
We are not blessed with all these orders. These are all in the writ petitions. It does. You should not. That's your incompetence or department's incompetence. You appeared when the order was passed. You must have a copy of the writ petition. Then who is to
Page
be
14,
blamed?
man. Page 14. 14.
So there was no difficulty. So the tribunal simply dismissed. And then you have shown the order of the division bench.
My lord, that was order was set aside.
Division bench set aside the entire order.
Order of that tribunal as well as the appellate authority.
Correct.
And directed, my lord, the last part, in view of our order, steps to be taken by the authorities accordingly in accordance with the provision of law.
I'm unable to comprehend the whole of the situation, sir. What you have perceived, I do not know. Three
My lord-
questions were raised before the prescribed authority. The first was a recording of Bargadar in the record of rights. The prescribed authority holds there is no difficulty. If anything is there, then you go and agitate this point in another forum. So far as the share of the produce is concerned, the prescribed authority says preceding 3 years he is entitled, and then ascertained the sum. Liberty was also granted to you to make an application. Then you went to the tribunal. Tribunal simply dismissed the OA application. Now the High Court, while considering the same, set aside both the orders. One reason was, then how can a authority restrict the share produce for a period of 3 years when there is more? It is more than that. So it's I would say an unreasonable premium which is given to such a Bargadar.
Right.
Can't be done.
Right.
And then set aside both the orders. What does it mean? Then inference one has to draw. And they consequential steps. What? I do not know.
Then, my lord, the
Interpret order, and if the order of the High Court is capable of many things, or say the order of the court is capable of many interpretations, then why they will be held liable for contempt? They can't. You may read it in your way. They have read it in their way, which cannot be said to be absolutely absurd.
my lord, the authority also clarified the order.
I do
Page
not know what
37.
clarification
Malad,
comes.
Page 36.
The order of the High Court, I do not know that what interpretation one can give.
There is no
Sorry, can't.
My lord, page 36, the authority also, my lord,
The contempt has to.
then my lord, kindly can to take appropriate steps, man.
No, we'll drop the proceedings.
My lord, kindly can leave, my lord, to take appropriate steps.
What?
To take appropriate steps, my lord, in accordance with.
They what appropriate steps they have to take.
No, they have stated, that is why I want to drop. Page
What they have
36.
taken.
That the court order did not any give direction upon the specific respondents. That point has been taken by the authority. That I have annexed, page 36. Kindly have a look.
But
And second thing, my lord, second thing, the appellate authority passed the order, the BLLR can't do anything. The order of the High Court set aside,
that is wrong. That
has been
because
stated.
the order of the appellate authority was set aside.
that is the BLLR stated.
You can't say that this
My lord,
order.
that is the BLLR stated, the High Court
That's the wrong.
set aside the
Where
order
it
of
is
the
said,
appellate
that's
authority
wrong.
and the tribunal.
We will direct the PLLRO to remain present. That is his understanding.
My lord,
of
that is
law.
the understand page
If
36.
the order of the appellate authority.
So we approach before the appeal
Right.
court.
Will he still go by the order which is non-existent?
Now, if may I read mine?
Go.
Subject to
Now, as the
all humiliation, there was no such direction on us.
I am asking you if the PLLRO has taken a stand that appellate authority has directed something, I will not do
My-
anything. How can he? The appellate authority order goes.
now may I read, my lord? May I read?
Then-
Now, as the Honorable High Court has set aside the judgment passed by the appellate authority and the Honorable LRTD, we can look back. The judgment of the Honorable LRT passed by in WP number such and such.
Can't be done. We are coming within 5 minutes and then.
Right.
But we will be very critical on these observations of the BLM.
Yes.
Page 36, man, of that contempt application.
No, we have seen that. No, perhaps let me place the case. The BLLRO has considered all the previous litigations, everything. Kindly come to from page, at least we should read from page 31, but still I am placing from page 34. Sir, this order of the prescribed authority under section 51A5, that is the appellate authority. But initially prescribed authority passed the order. I tell you why I say what is the ambiguity which we find. If you come to page 30, now I'm taking you to this. Come to page 30. There are three questions which were formulated. First question is page 30 of the WPLT. Yes. Yes. First question is whether the Borga recording is admissible at any stage of the preparation or revision of the record of right. This is a very important question. Correct? How it has been answered. Come to page 31. Considering just above the decision number 2, considering the above statutory provisions, it is decided that the Borga recording is admissible. Please, in KB stage. What is this KB stage? Khanapuri Bujara. Khanapuri Bujara. Yes. Though such recording may be challenged at the next stage available or may be appealed against. So what does it mean? That they hold that the Borga recording is justified in a Khanapuri
Bujara
draft. Well, at the time of Khanapuri Bujarat, one has to go and inquire, then draft. Khanapuri Bujarat, it was held to be correct. Yes. Correct. Then what was the second question? Next stage, they did not come forward and put their. What is the next question? Whether the notice was duly served and recording was made as per law. This question number 2 is answered at page 32 last. Yes. As regards service of notice, I do understand that the public notice for Khanapuri Bujarat was issued in 77. Recording was done in 79. In Khanapuri Bujarat, Khotiyan number such and such, and I am of the opinion that the same notice is sufficient to record Borga. So, held correct. Again, come to page 30, the last one. Whether the share of produce is deliverable to the owner by a Borgadar from the year of the Borga recording. Correct? Then come to the page 34. Page 34. In view of the facts and circumstances, it is decided that the Borga recording is or was justified. Decided further that the owner and the Borgadar would further follow the direction made herein. The appeal filed thus stand disposed of. Then, why it says disposed of? Then come to 33, last paragraph. Hence, I am of the opinion that the owners will be entitled to share of crop, not only from the last 3 years, but also for the entire share falling due from the date of Borga recording. Of course, the Borga would get the benefit of delivering share of produce or cash equivalent thereof by annual increment prescribed under section 82A. To get such share of produce or cash equivalent thereof from the highly potential and fertile property measuring such and such acres capable of producing 3 crops during each year, the owner will have to file an application under section 18(1) and the assessment of the crops be made for the entire period reckoned from the date of Borga recording. If such application is filed to the officer under section 18(1), within 1 month from the date, officer would entertain the application without raising any issue on the prior limitation or otherwise and settle the disputes by another 1 month. As already understood from the field inquiry dated such and such 2001, received from BLLRO Hon'ble, crops worth rupees 41,000 odd, 43,000 odd, 37,000 odd were produced during the last 3 years. That is 1405, 1406, 1406-7 PS. An owner is entitled to 1/4 share. This was critically examined by the division bench to be wrong. Now, the entire order was satisfied. What the division bench has said. Come to page 14. Sorry, not 14. The order of
1670, page 1670.
order dated 2nd of November 2006.
Yes.
Please come. Heard the learned counsel appearing for the parties, we have perused the order so passed by the prescribed authority under 51A5 of the Land Reforms Act. It appears that the said authority has specifically admitted in the order that at no point of time the Bargadar fulfilled the criteria as laid down in section 16(6). What is he then reproduced? It is crystal clear that the Bargadar neither delivered any share nor made any attempt whatever for delivery. The intention of the Bargadar as it appears is malafide. He simply agrees to deliver share for last 3 years. The statute based on equity, justice and good conscience does no intent to derive or deprive anyone from the legally entitled claim, though law aims at safeguarding the interest of the poor like Bargadar in the society. The question of entertaining any fresh application contemplated does not arise. Rather, the application for decision of dispute already exists, since the Barga recording and the filing of the WP in the High Court of Calcutta may still remain unsettled. Then it says, in these circumstances, we are unable to find how opinion can be expressed by the said authority that the owner would be entitled to share of crops, not only for the last 3 years, but also for the entire share falling due from the date of recording of Barga recording. When it appears to us that the ingredients of the section has not been fulfilled by the Bargadar specifically and which has been admitted in the order itself. The prescribed authority has no right even to pass such order as sought to be passed in this matter on 2nd August 2001. In these circumstances, we have come to the conclusion that the said order so passed by the authority is not sustainable under the provision of law has to be set aside. The order so passed by the tribunal is also appeared to us that the said tribunal has failed to appreciate the said situation and pass the improved order in the matter. Accordingly, we are of the opinion the order so passed by the learned tribunal is also not tenable under the provision of law, has to be set aside. Then, accordingly, the application so filed by the petitioner is allowed. Before we part with, we must also record that in spite of notices were served on the private respondent on several occasions, and the matter was adjourned by us to enable the private respondent to appear before us. On number of occasions, none of the said private respondent appeared before us. Accordingly, we have to hear out the matter in absence of the private respondent, and we are disposing of this matter as above. In view of our order, the steps to be taken by the authorities accordingly, in accordance, I do not know, authority.
Who is the authority? The appellate authority's order merged with the LRTT's order. LRTT's order merged with the Honorable Division Bench's order. Honorable Division Bench has set aside that order. Then BLLRO, they went before the BLLRO. BLLRO said, you go, please go before the appellate authority.
How can he? Sir, the BLLRO has passed an order which was challenged before the appellate authority. The appellate authority order was challenged by the before the tribunal. Both the appellate authority and the order has been set aside. Now it says steps to be taken by the authorities in accordance with law. What does it mean? They appliedly, if we apply the doctrine of merger, then the order of the BLLRO also goes because it must be the appellate authority's order. It never said. That goes. There was no existence.
We have learned from my lords,
the appellate authority. Please, the court has not said that you go to the appellate authority.
No, no.
Then
But if there could be two possible ways.
That is a different for the contempt. I am again
Yes.
saying, but how the BLL can direct that go to the appellate authority.
They need to, they are the landlord. They are saying they are not the Borgadars. Authority has passed an order
But
by,
the question is again, sir, when the order by which the Borgadar right was recognized is to set aside. Please consider the entire order, 3 questions. That's why I took you to these 3 questions. Though the reasons does not appear to be. I will not say anything on that.
I know.
But ultimately, the entire order was set aside. The moment the entire order is set aside, that means the declaration that correct by virtue of a Khanapurti Gujarat proceeding also goes. When it goes, then what is required? Tell me.
Subject to correction, regarding the record of rights, finally published record of rights, that was not questioned by the landlord.
What?
That was not questioned by the
I
landlord.
know not. There were 3 questions and he challenged the entire order.
Issue
And
was
the-
framed.
Sorry, the entire, what are you talking about issue was framed? What is the necessity of framing an issue? So that the questions which involved in the proceeding has to be decided. Then if the entire order goes, that means all the findings written on all such issues also goes. Then what is the implication?
I'll have to,
Then what is the implication?
again, then BLLRO has to
Absolutely.
take.
Absolutely. He is the first authority to decide.
Not any contempt. Contempt jurisdiction order to set aside.
Not making any comment on this order. I think the finding was restricted to a third question. Where the court was of the view that why 3 years and correct when he himself held that it should be from the date of the recording of the Barga and that is from 1979 onwards he has to pay. Then why it will restrict to 3 years?
Why this concession?
But the entire order was set. Had it been partly set aside, no difficult.
They have to now challenge this BLLRO's order, I believe. The order passed by the BLLRO.
Yes.
Or we need to start our proceedings. That's
What
how we can.
proceedings? What proceedings we will start? Private respondent Borgadar is not coming. They say that the recording is bad. Then that proceeding has to be revived. The court has found that what was the necessity of permitting him to make an application under section 18(1)? Why? That shows 18(1) means what? 18(1) is a what? What is the nature?
18(1). With regard to deposit of share,
16(4) is bhag.
the authority appointed under that provision who decide that issue, whether the amount, the share. You know.
Every dispute between a Borgadar and the person whose land be cultivated land he cultivates in respect of any of the following matters, namely division or delivery of the produce, recovery of produce under section 16A,
Third one,
then termination of cultivation by the Borgada.
so he has gone there. Since 79. He has not paid. So he may go for a termination. I do not know what application he has made.
No, his case is, my lord, that Borgadars, those who are appearing in their record of rights in their land, they were never ever Borgada, appointed by them.
The difficulty was because once they took a stand that it is not a Borgada, they're not, then their case falls under 18(2). Section 18(2) says that if in deciding any dispute is referred to in subsection 1,
There is also appellate provision.
any question arises as to whether a person is a Borgadar or not, and to whom the shares of the produce is deliverable, such question shall be determined by their authority under subsection 1. So this also is the inbuilt question. Will he not decide? And Khanapurti Bhojarat, setting up a shamiyan or a tent on an open land, and then inviting everybody from a village, come and say, and he comes orally says, and then everything is recorded.
Halka camp. That's Shamiana and
I
everything.
know, that's why I say in open land. And then standing there, and then anybody comes, I am there, recorded.
Operation Borga.
Kumra objection now again.
For the contempt laws.
Well, let the BLLR sell, correct the record of rights. Or revive that, the records. That is my prayer.
Without proceedings, record of rights correction.
Though the aforesaid applications have been listed today relating to a restoration of the contempt application, which was dismissed for default upon condonation of delay in filing an application for restoration. But we invited the attention of the respective classes to the merit of the instant contempt applications, and by consent of parties, we proceeded to hear out the application for contempt itself. Since we decided to enter into the merit of the contempt application, the application for restoration upon condonation of delay is allowed. The contempt petition arises from a judgment and order dated 2nd November 2006, filed by passed by the division bench, disposing of the writ petition number WP LRT 148 of 2002. The dispute relates to recording of Barga in respect of the subject property on the basis of a Khanapurti Bhojarat proceeding initiated in the year 1977. The record of rights would indicate that the private respondents in the writ petitions were shown as Borgadar on and from 14 to 1979. And a KB Khatiyan number 254 was opened. The writ petitioners challenge the entry in the record of right, where the private respondents of the writ petitioner were shown as Borgadar before the competent authority under the provisions of the West Bengal Land Reforms Act 1955. The competent authority, which in this case is a block land and land reforms officer, upheld the entry made in the record of rights, which was challenged by way of an appeal by the predecessor of the instant writ petitioner, instant contempt application before the appellate authority under section 51 within bracket 51 capital A within bracket 5 of the said act. The appellate authority framed three questions, namely one, whether Borga recording is admissible at any stage of the preparation / revision of record of rights. 2, whether notice was duly served and recording was made as per law. 3, whether the share of the produce is deliverable to the owner by the Borgadar from the year of Borga recording. The first question was answered by the appellate authority in affirmative. Upholding the Borga recording at KB stage, Khanapurti Bojarat stage. With further, with stipulation that in the event the predecessor of the present petitioner felt aggrieved thereby, the same may be challenged at the next level available under the law. While answering the second issue, the appellate authority held that the public notice for issuance of the proceeding, for issuance of KB proceeding was issued in 1977, and a separate KB Khatiyan number was opened, which itself connotes the notice to be sufficient to record Borgada. Next, so far as the third issue is concerned, the appellate court, though held that from the date of recording, Borga, the Borgadar is liable to pay the share of the produce, but restricted the deliverable of produce preceding 3 years from the date of the application taken out by the predecessor of the petitioner. And also granted liberty to the original applicant of the contempt application to file an application under section 18 within bracket 1 of the West Bengal Land Reforms Act 1955 within 1 month therefrom. And if filed, the same shall be treated to have been filed within the period of limitation, and the concerned authority would decide the same in accordance with that. The order of the appellate authority was assailed before the tribunal in OA 2372 of 2001. The tribunal affirmed the order of the appellate authority without recording any independent finding therein. To stop. The said order of the tribunal was assailed before this court in WP LRT 148 of 2002. The division bench, by an order dated 2nd November 2006, found that neither the order of the appellate authority nor of the tribunal nor of tribunal are sustainable in eye of law, and in fact set aside the said order and directed the steps to be taken by the authorities in accordance with the provision of law. The contempt application is taken out that despite the order of the appellate authority as well as the tribunal having set aside by the High Court, the name of the Baghdadar is still shown in the record of rights, which ought to have been corrected and or rectified by the authority. Such being the substratum of the allegations concerning the contemptuous acts allegedly committed by the respondents herein, it is to be seen whether the order dated 2nd November 2006 contemplates such a stand taken in the instant contempt application. Next one. We are not unmindful of the proposition of law that if the order is capable of more than one meaning, and the LS contemners have adopted a recourse on one of such meaning assigned to the order, he cannot be held guilty of violating the order of the court consciously, willfully, and or deliberately. Stop. The order which appears to be ambiguous and cannot be reasonably ascertained with certainty the consequences to follow, the perception of the petitioner in interpreting the said ambiguous order does not ipso facto render the inaction or action of the authorities contemptuous within the meaning of the contempt of courts within the peripheral of the contempt of courts within the peripheral of the Contempt of Notes Act. Stop. However, it is vociferously submitted by the counsel for the petitioner that the moment the order of the appellate authority as well as the tribunal are set aside by the division bench, the BLLRO is required to take steps in this regard. But the stand which is taken, as shown in the contempt application, that the BLLRO has shirked his responsibility and relegated the parties to the appellate authority. There appears to be a justification on the submission of the petitioner in this regard, for the simple reason that the order of the BLLRO merged with the order of the appellate authority, which was subsequently merged with the order of the tribunal on being affirmed. And the moment the orders are set aside by the High Court, the order of the BLLRO cannot be allowed to stand and therefore has to be revisited, as the doctrine of merger would apply in such case. Furthermore, the High Court did not direct the matter to be decided afresh by the appellate authority. But what was intended after setting aside the orders of the appellate authority and the tribunal, that the steps as permissible under the relevant provision of the law should be taken by the authorities. The competent authority is required to consider afresh the moment the order is set aside, either to continue on the application filed by the predecessor of the petitioner, or by initiating a suo motu proceedings, provided such power can be exercised within the period of limitations provided in the relevant statute. 60 years or 80 years now? Suo motu proceedings, 60 years or 80 years?
That is under West Bengal Estate Acquisition Act. Under this one, 60 perhaps.
60 or 80?
Not 80, not. Land becomes.
Anyhow.
Under estate acquisition, the president has not given the last assent. So it had expired on 2017 November.
So that's why I said both the situations. You'll have to consider. Stop. Yeah. The issue cannot be permitted to remain undecided for all time to come. And it is an ardent duty of the authority to bring it to its logical conclusion at an earliest. Since we have indicated herein before that the order dated 2nd November 2006 passed by the division bench, 60 or 80?
51A4 is 35.
Has been amended subsequently.
Yeah, now I am told, I do not have the last notification. I do not have the last notification.
I believe I had an occasion to look at it. It is amended. I think the extension has been done.
44 2A 2017. And this one, my lord, I'm told that last extension was also not given.
The proceeding was there in 2001, no difficulty. Any,
My lord, I'm sorry, my lord, last, my lord, notification is says no limitation.
limitation. Is capable of more than one interpretation and appears to us also. That's it. More than one interpretation, and therefore, if the authorities, the respondents have resorted to one of such recourses, it cannot expose them liable to be punished under the Contempt of Courts Act. And accordingly, the contempt application the contempt is dropped. Rule if there be any issued upon the respondents are hereby discharged. However, we find that the dispute is lingering for more than several decades, and therefore the authorities must show alacrity in deciding the cause within a specified time, and we therefore direct the competent authority to decide the issue within 2 months from the date of the communication of this order, after affording an opportunity of hearing to all the interested persons. Upon recording the proper reasons in accordance with law. It appears from the order dated 2/1/2006 that the private respondents in the writ petition, despite the service, did not participate in the hearing of the writ petition. And therefore, in the event the notices have been served and they do not respond to such notice, it would be open to the competent authority to proceed with the case. In presence of the ministers.
I'm sorry to butt one one more thing, my lord, we are
First is একটা ভুল হয়ে গেছে, একটা বড় একদম প্রথমে থেকে। This is an application seeking substitution has been allowed or not?
No, not allowed.
This is an application seeking substitution of the heirs and legal representatives of the deceased petitioner. We do not find any grounds denying the same, as the right to sue survives upon the applicants. Accordingly, the application is allowed. The applicants shall be substituted in place and instead of the deceased petitioners.
regarding whether Borgadars who have been recorded, whether they are alive or kicking, my lord, that
Grateful.
otherwise against the dead person, my lord, again order.
Anapuri Pujara, you can go to the mart or a field, you can do everything, you can go there also.
Petitioner will supply them.
You can
Any
go there
land
also to
they are
find out.
but they will not.
Similar way, you can go there and find out.
Or carriage of proceedings is with you.
Because you have to sustain your record of rights.
And all the application disposed.
All applications disposed.
My application, my lord, is my lord, my application, my lord, pursuant to last day's order, my lord, I have served. This is the affidavit of service.
My lord, I am happy.
On application, there is a review, my lord, petition, first one.
I am appearing on behalf of Union of India.
Review is that, my lord, is division bench order was there, which is under review, and which is originating from this, and there is a section 5 application also. My lord, original number is 3005 of 2013 and 3006 of 2013.
3005 is the cat, 306, 3006.
It is a review application. It's a change brief, my lord.
দুটো can one কিভাবে হয়?
My lord, it is a change brief, my lord. Old, it is a change brief to me. Why I am saying so, the documents.
So you
No.
have inherited the asset,
Asset,
inherit the liability.
liability also.
Inherit.
Now, my lord, question is that,
Privilege to a council to appear on a change brief.
yes,
Not
Always.
a privilege,
I am privileged to appear before this court.
not a privilege,
No, that special privilege I got.
because
Only
you have deprived one of your brethren
Yes.
member.
My lord, one thing is that order under review is a judgment by the division bench of this honorable court, which was tested in the SLP.
Section 5 you have to overcome.
Yes, so section, I'm just giving it.
Must delay.
There is a delay, my lord. The order was passed in the writ court. The division bench order passed the order in a WPCT petition arising out of the
What is the total?
delay means, my lord, date of
516 days.
16 days and
160 days.
16 days.
516 days.
500
Lordship.
500
16 days.
16.
But I am submitting, my lord, with
more than a year, then.
more than a year.
Yeah,
Why, my lord?
yes.
He has this unfortunate petitioner is a
The
teacher, was a
special
teacher.
petition is dismissed.
Dismissed, thereafter preferred
SLP.
special petition before the Honorable Supreme Court.
That is all.
I am talking about special petition files only before the Supreme Court, sir.
Yes.
Lordship.
When I say special petition dismissed means the dismissed by the Supreme Court.
Yes.
Can a High Court take a special petition? Under Article 136? No.
Subsequently, this review is filed.
One of my client, my lord, who was a teacher acting in the Gangtok Kendriya Vidyalaya, my lord, his proceeding was initiated against him. Only one line in on the merit. Then after I coming on this, the totally, my lord, ignorant of the record, which is apparent on the record, no court, no forum, even the disciplinary in the High Court, I will convince. He has been victimized of the situation. There is a clear-cut piece of evidence lying with me, which was suppressed by the respondent authority that he was not at all involved, admittedly written, with any sexual offense. On that score, my lord, the allegation was
When
there.
the review application is filed,
Review
was
application is
filed
filed.
on 19th of March, 2013. The special petition was dismissed on 19th of April 2012. So nearly 11 months one
Yes,
can
my- yes, my lord.
see therefrom.
So, but thereafter,
Why you took 11 months after the
no, he
dismissal?
says that
to
what
file?
he tries to establish, paragraph 5 and 6. He says that he has to face n number of litigations before the
What?
forum.
Very depressed. Do you have the documents? Because the depression
No,
is
only thing,
also
madam.
been treated
Only-
by the doctor.
No, no, madam. I'm not talking on that.
So
My absolute submission is that this is the case, my lord. His depression, my lord, came because he was totally under starvation, my lord. His family was ruined. Because of these things, his wife was, he was also expired. He was paid no salary. Even
there was no suspension of his service, but he has not paid even the subsistence allowance. Such being the situation, my lord, I continue the litigation from the disciplinary authority, from the stage of letter of termination. Then I objected to the charge, memorandum of the charges, no, and thereafter I went to the tribunal. The disciplinary authority, the High Court, nobody has looked into the report of the preliminary inquiry, which has been suppressed. I have somehow taken it, and the part of the record is that the entire allegation is false. And he has been socially victimized, my lord. His daughter's marriage was also stopped because of the social infamy. Out of this situation, my lord, kindly think that the prudent man cannot survive. It is not the case he has not challenged before any forum. It is the case he was not lackadaisical in his attitude. It is the case that he always tried before the forum. He challenged. Sometimes, my lord, he could not survive. One thing is that his social infamy. He could not survive because no subsistence allowance paid. His wife was dead. My lord, thereafter, my lord, old parents of 90 years or 80 years, 85 years, they are suffering now in the hospital. Only thing, a substantial right is there. If substantive right is to be adjudicated, I will simply show one document. It will suffice, my lord. One document, it will suffice. Kindly allow me to overcome this situation. And Supreme Court also passed a non-speaking order, my lord. Kindly, my lord.
What?
Supreme Court passed the order rejecting the special leave petition with a non-speaking order. The order itself, before the division bench which was passed, comparing with the another case, the case of that case is totally different. my lord. Kindly give me a chance, my lord.
Any reasonable man believe the story set up by you for Section 5? Can any reasonable man would believe?
I am leaving it to your lordship.
Absolutely, it appears that the false story is made out by you.
In the Section 5.
Absolutely,
In
it
the
is
Section 5.
apparent, sir.
In the Section 5.
Apparent.
If there be the so, my lord, I am respectfully submitting. Your lordship, I do not need to place any judgment. Your lordship knows that if it is a substantive right, I am not paid a single paisa.
So the limitation has to be ignored.
No,
because it is a substantive right. So the limitation
No, never I say.
act should be ignored
on that
immediately,
case-
and the court will
That case, my
decide it.
respectful submission is that
Sir, what you have stated?
I have seen
you
that.
realized that?
I have seen that, my lord. Somebody
So
has.
can any reasonable man believe the story?
I am not on that, my lord. That is why.
So
I am leaving only. I am seeking discretion of your court. I will take just half an hour so that on the merit matter.
half an hour.
On the merit, today, not today. On the merit of the matter, 10 minutes.
Section 5. We
Allow
are
me,
at
my lord, ignore this Section 5 if possible. It is not drafted by me. I cannot blame any lawyer who has drafted. It is not drafted by me.
sorry, you can't. When you are appearing, you must owe the
Yes,
responsibility.
but I can, my lord,
Can't.
if your lordship and allow me, my lord, I can say that what illegality has been done. What illegality has been done, that I can say here and now.
Obviously, the certified copy was obtained on 19/4/2012 Supreme Court special petitionকে dismiss করলো। Story এখান থেকে বলছে যে being aggrieved by preferred a special petition which was dismissed. তারপর বলছে যে depression এসে গেল, এই এসে গেল, হয়ে গেল paragraph 5. Paragraph 6 এ বলছে after somehow he recovered, he বলছে contact the present advocate and sought an advice. ওকে জানি না হতে পারে 94 এর পর 24 পর 24 তারপর বলছে this is after going through the documents and says that the special petition is dismissed will not constitute as a correct. Then he says that since there was an error apparent in the face of the record of the judgment, intervention of this court for filing a written. Then 9 বলছে that this application states that the application for certified copy of the judgment was filed on 24. It is not the thing. Then তারপর নভেম্বরে হয়ে গেছে, তারপর ফাইল হচ্ছে ফাইল অন 19th রিভিউজ ফাইল অন 19th এখান থেকেও দেখা যাচ্ছে যে 4 মাস absolutely nobody will believe you had a certificate.
For the ends of justice. Otherwise, my lord, no forum has.
For ends of justice, in accordance with law.
Kindly give me that opportunity, my lord. So kindly, any day, I will take only 10, 15.
No, it's
My
a
lord,
section
this
5.
is totally
We are,
false, my lord.
we are on section 5, sir.
Yes, my lord.
That's
But
all.
I will, my resolution.
That's all. We are not on a
My
merit.
resolution submission is that, kindly
Yes.
hear me, my lord. If this section 5 is not allowed, what will be the consequences? My lord, kindly, what will be the consequences for
What?
me? Consequences is that.
No.
No.
What do you want to say?
I want to say, my lord, the section 5 application, in this case, is a discretion of this court, I know. If the court thinks that if a petitioner's right has been illegally taken away by a respondent authority with a false allegation, admittedly here.
How can a court arrive at the decision? In section 5, the court will arrive at
No,
the
my lord,
decision.
I have
Our
given
court
him-
will be guided by the explanation
I have
offered by you for a delay.
delay.
And if the application does not appear to be satisfactory, is it a mandatory on the
My
court to
lord,
still grant?
My lord, I know that. My lord, your lordship has come across several judgments. I'm not on that. Kindly consider this one. If
It's an
anything,
unbelievable story, sir. You have set up.
it is not a setup story, my lord. He left
It's
the.
an unbelievable story.
Kindly let me read the paragraph 5 and 6. He has said something, tried to say something, and something has been drafted, my lord. I am not on that. That is why. I am not on that only concentrating on the pleadings. I am considering the merit of the case. That is why kindly allow me so that I can show any forum, even the Supreme Court did not at all look into that document, which is showing that the student itself has admitted it is a false case. He has no sexual relation with the particular student. He has been alleged, infirmed by the concerned respondent school teacher. One of the teacher is behind that. Kindly give me an opportunity, my lord. It is a question of bread and butter. And not only that, my lord, a social dispute, my lord, infamy. That is why, my lord, paragraph 5 and 6, my lord, your lordship is trying to say that it is not believable story. My lord, if it is a substantive right, my lord, a person's total service period since 2004-6, I am struggling with the disciplinary action. Thereafter, I came before the tribunal twice. Thereafter, again, disciplinary action was started before the appellate authority, inbuilt disciplinary authority, appellate authority of the disciplinary body. Thereafter, again, the CAT, Central Administrative. Thereafter, my lord, judgment was passed by the Reed Court. That time, up to that time, no delay. Only when judgment was passed on the Reed Court has compared this matter with another one matter and passed a common judgment. My lord, the entire facts is wrong, story is wrong, documents are different, cause of action also different. And I am being victimized. I filed an SLB, my lord, which was rejected or by a non-speaking order. My lord, since my lord, kindly give a chance, my lord. If I am not at all on the right point, but immediately reject my application, my lord. Nothing else. Immediately, I will not. I will have to give my lord chance to
We are
section
considering
5.
section 5.
On the
We are
merit of the
considering
matter, my lord,
section
can be
5.
disposed of. Merit of, I can place the preliminary inquiry report. They have suppressed it one after another RTI application. My lord, kindly take it, my lord. Your lordships. I have made, my lord, as the documents are not annexed properly, or your lordship, kindly consider. I will show one document. Kindly consider. Then, my lord, on merit, my lord. Then kindly consider what injustice has been done with this man. False story, which is equated by more false action by the respondent authority. But on a false story, if the limitation is set up, but equated more false story by the respondent authority. They did not acted upon on their own preliminary inquiry. Preliminary inquiry
I
report.
think there must be, we have given you a ample opportunity to make the submissions. We have not interacted you. We indicated. Now let us decide the section 5 applications.
With a little bit opportunity, my lord. On the main.
More opportunity, sir.
If you are
You are live, sir. Entire country is watching
yes,
what
I
you are
know,
saying.
I know. But my lord, at the
Sir,
same
we
time,
have given you an opportunity.
Kindly.
You have argued the matter. Section 5, we are just
kindly let me
sticking
place one Supreme Court judgment. If it comes to my
no difficulty.
Permit,
sir. What?
But I cannot give what is more than the law. I cannot submit more than anything in the law. Kindly try to appreciate, my lord, this judgment, my lord, where these provisions limitation has been discussed. My lord, section 5 object has been discussed. My lord, kindly take up the paragraph 21, 33 and 34. Kindly come to the paragraph 33.
Paragraph
33. My lord, I am giving the page number, my lord. Paragraph 21, my kindly come. It was in the Paragraph 33 is page number. It is an arguable case, my lord. Somehow we have lost in any other forum. 33, my lord, I will look into. Page 33, my lord, wrong. Page 33 can be taken up. My lord, kindly take up the paragraph 55, page 33 of this judgment. Where a Supreme Court
Page 33 or
page 33.
page 33?
And one Supreme Court has been relied upon.
Yes, sir.
This, which is in the paragraph 55. The quoting
Yes,
the
sir.
judgment of Brahmopal versus National Insurance Company.
Yes, sir.
Here they have stated that. This court has firstly held that the purpose of conferment of such power must be examined for the determination of the scope, and such discretion must be conferred upon the court. Then our analysis for the purpose of the suggests that such discretionary power is conferred upon the court to enforce the right of the victims and their dependents. The legislature intended that the court must have such power so as to ensure that the substantive justice is not trumped by the technicalities. It is my point, my lord. If this is the case, my lord, and another case is that, then my lord, kindly come to the next paragraph, my lord, where my lord, gross negligence and lackadaisical attitude has been discussed, whatever your lordship falling from your lordship's mouth. Paragraph 24. It says when a right has been accrued in favor of one party due to gross negligence and lackadaisical attitude of the other, the court shall refrain from exercising its aforesaid discretionary relief. It is whatever is lordship falling from your lordship's mouth. Then kindly come to the another paragraph, my lord. Page 21. Maybe page 21. 33, 34.
Yes.
So this is all the judgment has been, what is meant by the sufficient cause? My lord, that is in page number 32. The Supreme Court has elaborately discussed in the Ajmer Court versus State of Punjab. Paragraph number 54, page number 32. My lord, the concept of the reasonable time, at the few lines from the bottom I am reading, because it will not waste your lordship's valuable time. The concept of reasonable time in the facts given would be most appropriate, and application must be moved within a reasonable time. The facts of the present case demonstrate that the redetermination under section 511 of years after the death of the Kartar cow, after 6 years, that application was preferred. That is why it was rejected. And my question is that if it is repeated with the technicality and the substantial justice, my lord, kindly give me one chance, my lord. I will not take very long time. As time stipulated time, I will place my case. I will show that entire falsity is on the record. No court has looked into this particular document. Why, I don't know. Neither the lawyer has placed this or the court overlooked it. My lord, that is why, my lord, kindly, my lord, give me a chance on the ground of this point. On the grounds of this point, my lord, otherwise, this question, my lord, will ever determine in accordance with law. Kindly, my lord.
That's all.
Now, leaving
Now you feel an ample
lordship,
opportunity of hearing is given to you.
and my lord, rest will be done, my
At
lord.
least the,
My lord,
at least
rest may
the
be done, my lord.
satisfaction.
Rest may be done by your lordships also.
Yes.
Rest
Thank
may be
you.
done. Rest
Thank
may
you.
be done
Then
by your
let
lordship.
us dictate the order.
Your lordship will always,
Yes.
your lordship will every
Yes.
time you
Thank
speak.
you. Yes, we are coming back at 2 and then we'll dictate the order.
My lord, I will come back with a lot of expectation. With some good expectation, I maybe come up.
What?
With some expectation of the good.
I could not get you.
With good expectation, let me come.
We don't know. Law does not either
broad principle
recognizes the good expectation or bad expectation.
I can request your
It
lordship one
will
thing.
go by its own course.
I can request only one thing. The rejection is, it can be done. But my lord, substantial justice may be considered. Nothing else.
Let
If
us
it
see
can
what
be, my
is
lord,
what is
somehow.
a
This
what is the
unfortunate
concept
fellow,
of
he is
substantial
totally
justice.
infirm person. He cannot
Yes.
come to the court. Kindly,
We are coming at
gratefully much.
Yes.
My lord, may I have your lordship? Just may I have only one kind indulgence, my lord? In one matter, your lordships have passed the order and it was supposed to be uploaded. The petitioner is a doctor.
We don't have any control over the uploading. Don't worry, it will be uploaded today itself. Yes, come. Lakho. Admittedly, there is a delay of
516.
516 days in filing an application for review of the judgment dated June 23, 2011, passed by the division bench in WPCT 351 of 2007. An application for condonation of delay is filed for condonation of delay in filing an application for review primarily on the ground that after having suffered the termination/dismissal from service upon a full-fledged inquiry in the disciplinary proceeding, the steps could not be taken promptly. Full stop. A little prelude to the genesis of the litigation is required to be adumbrated before we embark our journey on the peripheral of a sufficient cause.
being of paramount importance in condoning the delay in filing an application for review. Admittedly, the petitioner was engaged as physical education teacher in Kendriya Vidyalaya, Binaguri, West Bengal. Stop. On a complaint being received from one of the students of the said school, alleging moral turpitude, a preliminary inquiry was held, which culminated into the order of dismissal / termination from service. After having found such allegations substantiated by a cogent evidence, the order was assailed before the tribunal, and having unsuccessful therefrom, the writ petition being WPCT 351 of 2007 was filed before the division bench of this court. By a judgment of June 23, 2011, the writ petition was dismissed after returning findings both on facts and law, which was further assailed before the Supreme Court by filing special leave to appeal within brackets civil number 38 of 2012. Full stop. The said special leave petition stood dismissed on 19/4/2012, and thereafter the review application came to be filed on 23/11/2012. Such being an undisputed, next paragraph, such being an undisputed facts discerned from the record, the seminal point involved in the instant matter is whether the petitioner has been able to make out a good cause which may constitute a sufficient cause for the purpose of condoning the delay in filing the review application. The facts narrated up to paragraph 4 relates to the incidences relating to initiation of the proceedings against the petitioner, which reached up to the Honorable Supreme Court. Stop. The explanation is sought to be offered from paragraph 5 onwards, which according to the learned advocate appearing for the applicant constitute a sufficient cause for condonation of delay in filing an application for review. before we proceed to adumbrate the narration of the facts emanate from the said application, it would be apposite and profitable to recapitulate the law in relation to the exercise of jurisdiction by the courts in dealing with an application for condonation of delay. We are not oblivious of the fact that length of delay is immaterial, which could further be eminent, which would further be evident from the language employed in Section 5 of the Limitation Act, which would further be evident from the language employed in Section 5 of the Limitation Act, wherein a discretion is given to the court to condone the delay, provided the court is satisfied that the circumstances which occasioned the delay in filing a proceeding within the statutory period was beyond the control of the petitioner, or the laches in approaching the court belatedly cannot be attributable to the conduct of the litigant. Though sometimes a distinction is sought to be made within court's good cause and within court sufficient cause, yet we feel that such a distinction is blurred the moment the court found a sufficient cause to have been shown. It would always be regarded as a good cause. There cannot be any straitjacket formula, nor by using the Pythagoras or the Euclid's theorem the sufficient cause can be squeezed within such formula, but largely depends upon the facts of each case. The sufficient cause is of wide connotation, varied in form, and therefore depends upon the case to case. Stop. What may cause a sufficient, what may be construed as sufficient cause depends upon the quality of the narratives pleaded in the application and the conduct of the litigant in proceeding with the case, and therefore gives leverage to the court to exercise a discretion on the attending factors perceived from the pleading of facts. The emotional rhetoric at the bar does not dispense with the ardent duty of the court to ascertain the sufficiency in the cause shown in the said applications, as neither the emotions nor the sympathy has any role to play in exercise of the discretion vested upon the court. The court shall be guided by the factors perceived from the pleadings, and also perceived from the pleadings, relatable to the conduct of the litigant, whether such litigant was vigilant and careful in taking all steps as the normal man, or as a normal man would take if subjected to litigation before the court of law. Recently, a practice has developed at the bar when an application for review is filed after taking change from the erstwhile advocate who appeared and argued before the court, and invite the court to revisit and or rehear the matter in the garb of an error having committed, in the garb of an error apparent on the face of the record. Look, even sometimes the change is taken from the filing advocate of the review application, and engaging a new lawyer or set of lawyers to argue the application for review from a different approach, and invite the attention of the court that the judgment under review ought not to have been passed if such points was argued or may have been argued. Full stop. We do not intend to delve much further on the above aspect. After noticing the judgment of the Supreme Court rendered in case of blank versus blank, reported in AIR 1997, Supreme Court 1009. Reverting back, next paragraph, reverting back to the application for condonation of delay, as indicated above, the sum and substance of the narrative which we gathered from the meaningful reading of the averments made therein is that the petitioner, after having suffered a sudden jerk of dismissal and or termination from service could not take prompt steps, nor was in such mental state of affairs to take a decision. And therefore, such circumstances must constitute a sufficient cause. We do not find we do not find any delay in taking of various recourses available to the petitioner in law before the appropriate forum. The order of the tribunal was challenged promptly before this court, and after the dismissal of the writ petition, the same was further challenged before the Supreme Court by filing the special writ petition. The moment the special writ petition is dismissed on 19/4/2012, the story of mental depression or being perturbed with the penalty having imposed upon him in a disciplinary proceeding, steps could not be taken. The subsequent paragraph after paragraph 5 would indicate that after 24/8/2012, when the petitioner felt that he has recovered from such depression, contacted the learned advocate to seek an advice on the next course of action. Paragraph 7 would indicate that the said learned advocate correctly advised that mere dismissal of the special writ petition does not tantamount to the merger of an order of the High Court into an order of the Supreme Court, and therefore the review is maintainable. Obviously, the aforesaid stand has been taken having considered the judgment of the Supreme Court in Komayat Din, the 2000 volume 8 SCC. পাতাটাও বলে দেব। Though the issue relating to the maintainability of the review upon a dismissal of the special writ petition has been taken, but we do not intend to go into the above aspect for the present, as we are confining our consideration to the application for condonation of delay. Even after securing such an advice, a further certified copy was applied, which might have been obtained earlier when a special writ petition was filed before the Supreme Court. And there has been a considerable delay in filing the review application. The moment the petitioner has exhausted the remedy by approaching the Supreme Court under Article 136 of the Constitution of India, and if the petitioner feels that the proper remedy would be the review of the order passed by the division bench, we do not find any impediment in seeking leave of the court to take immediate steps for filing the review application, as the earlier certified copy, or the copy, as the copy of the photocopy of the earlier certified copy was available with the petitioner. Be that as it may, since the certified copy was applied and handed over to the petitioner, on 9/10/2012, there appears to a further delay of more than 1 month in filing the review application. The story of undergoing a depression or being mentally disturbed is unbelievable, nor we find any supporting document in this regard. The person who has suffered a depression is supposed to take a medical advice and or help, and have to undergone medication in this regard. Stop. Mere using the expressions depression does not wipe out the consequential steps to be taken thereupon, nor the court would be invited to believe such statements without any supporting document in this regard. Interestingly, the paragraph 5, wherein the story of depression and or mental disturbance is pleaded, has been verified as the matter derived from the record, which should be believed to be true. There is no record which would corroborate such depression or the mental disturbances. And therefore, in absence of any such record, which do not form part of the instant case, we are unable to believe the story set up by the appellate petitioner. Time and again, the courts of the country has held that a liberal and or lenient approach must be adopted in a case, on an application for condonation of delay, but it does not dispense with the onerous duty of the litigant to narrate, to make out a case which is believable in a normal course of events. Full stop. The lenient and liberal approach can only be adopted provided the sequitur of events constitute a sufficient cause, despite there being a negligible lapses on the part of the litigants. The reliance is placed upon a judgment of the Supreme Court rendered in case of Government of Maharashtra within bracket Water Resources Department, represented by Executive Engineer versus Mrs. Borse Brothers Engineers and Contractors Private Limited, reported in 2021, Volume 6, SSC, page 460. In support of the contention that the court should not take a strict or pedantic view in dealing an application for condonation of delay, but adopt a liberal and lenient approach, as the meritorious matter should not be nipped on the anvil of the Limitation Act. The case involved in the said report relates to the various provisions contained under the Arbitration and Conciliation Act 1996 vis-a-vis the Commercial Courts Act 2015. It is no longer res integra that the special period of limitation provided in the special statute has to be strictly observed and if there is no power conferred upon the court to exercise its discretion beyond the outer cap provided therein, it denudes the power of the court to exercise such discretion. Obviously, the discretion has to be exercised reasonably, rationally, and within the well contours of the statutory provisions, as the legislatures never intended to vest the court with such powers which runs beyond the circumference of the statutory provisions. There is no quarrel to the ratio culled out from the said report that কি বলেছি? That the discretionary power to condone the delay must be exercised in the attending facts and circumstances. And the concept of reasonableness must be adhered to in the following bole এই paragraph 55 টাকে কোট করে দাও এখানে এই জায়গায় 55 টাকে কোট করে দাও এটা বলে দিলাম তো এটা আছে তো এটা গভর্নমেন্ট অফ মহারাষ্ট্র দেখো the next part the apex court in government of Maharashtra ওই যেটা আছে Supra also noticed the earlier judgment of the constitution bench decision rendered in case of Abdul Rahman Antule versus R.S. Nayak reported in 1992 volume 1 SCC 225. না কি বলেছি further notice ওটা কেটে দাও further notice the না 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 further notice the earlier judgment of the Supreme Court তারপর কেটে দাও in case of Basava Raj versus land acquisition officers reported in 2013 volume 14 is SCC page 81 wherein the apex court summarize the scope, jurisdiction and powers of the court in relation to a condonation of delay in the following bole paragraph 15 take quote kore dao in view of the law expounded above, it admits no ambiguity that there is no hard and fast rule for condonation of delay in initiating a proceeding before the court of law, as it largely depends upon the circumstances and the facts narrated therein. Stop. In the event the court found that such circumstances was beyond the conceivable control of the litigant. And he all along acted bona fide and diligently, there is no fetter on the part of the court to exercise discretion in condoning the delay. However, if the conduct of the litigant smacks of negligence, and the latches can be seen therefrom, such discretion may not be exercised as the condonation of delay is not a matter of right. Full stop. The facts as narrated here in above does not instill our conscious mind that the litigant was diligent and careful in approaching the forum within the stipulated time provided in the statute, and therefore we do not find any justification in exercising discretion by condoning the delay. The application is thus dismissed. With costs assessed at how much?
It's nothing.
10,000.
Jobless person. Jobless, long backlog, jobless.
Can't remain jobless for all time. Yes.
Jobless person,
10,000.
I have to pay for him. Illegal, I have to pay for him because he has no pocket money. All we doing very voluntarily. He cannot afford money. Better to put him in the imprisonment.
I have to pay. Yes, yes, 10,000. To be deposited with the State Legal Services Authority
Not their client.
within 2 weeks from date, or within 4 weeks from date. Such amount, if deposited, shall be kept in an account earmarked for juvenile, for providing the school fees of a girl, any of the girl child. That's another punishment you must suffer because of the facts of the case.
The one little intelligence I will pray, as because there was a prelude, my lord. As because there is a prelude, my lord, of facts. Or always my contention was that no preliminary inquiry report was given to me, and it has not been considered by any court of law. Kindly record that. It has not been my submission. It has not been considered by any court of law. No preliminary report has been considered. And that is the answer to this litigation. Kindly record.
In an application for condonation, then cost would be 5,000 more. We'll record. In an application for condonation, is it necessary to record such submissions?
I am leaving to your lordship. Am I leaving it to your lordship?
No, I'm just asking you. You are
do not
making
know,
a
my lord.
submission.
Lordship on that side, I am just feeling it, my lord. Whatever lordship is passing the order is rightful on my conscience.
Only thing cost part may be cost part may be dispensed with. He has no means, my lord.
No, no, let him,
He is waiting outside the court.
let him
Infant person.
spend for the good cause. It's not going to them. It's going
He has
to
not done anything.
a very
Even
good
then,
cause.
out of the record, I just say here.
After all, he was a teacher, so he will
Long
definitely
back, my
take
lord.
care.
He is left out of his job
Sorry.
since 2006.
Let him.
He has nothing, no means to survive.
Let him. Let him deposit.
My lord,
Sorry.
kindly
Next.
record this that I have been suppressed here, my lord. Everything has been suppressed. So for the preliminary inquiry report till date, they have not given it to me. This is the case. Inquiry report given a clean sheet to the person.
I think in a constitutional provision, there is no post-mortem provisions which is there. It is in a criminal cases.
No, my lord.
After the judgment is already dictated in the open court, does it invite a further post-mortem of the judgment?
No, that has been considered. That is why the review was prepared. That is not considered by any court. That is why review has been prepared. Some person should be dealt with some equity, my lord. He has blamed, my lord.
Call the next matter.
Kindly record that submission, my lord. I shall be
What?
that this preliminary record was suppressed by them.
You
This
want
is-
a recording of that?
No, it is not recorded. Preliminary
No,
report.
no, you want a recording?
If you are believing your lordships, I am not pressurizing.
No, 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 it is up to you. Because I have a very strong view. If the argument is advanced at the bar, I will definitely record and consider that on. I am of a very strong view. If you say that you are making this, then we'll record it and then we'll record our finding on that as well. I have no hesitation.
Okay, my lord, let it be. Let it go, my lord.
Let it.
Let it go. I do not want that person to go. Only 10,000 rupees is to be paid from us, from our benevolent fund.
You have seen what allegation has been made against
Allegation has
you.
been seen, my
And
lord.
for that, this particular, the cost is an apt and appropriate. The respect for a student must always be there. Do not try, because we have seen that where is an admission and thereafter how you
I must say,
digress therefrom, that it has been obtained by using a force,
I will say
whereas
one
you have admitted your signature on that particular admission.
thing. May I?
Don't
Only
say so. We do
Only
not
one-
want to
one-
go into all these aspects. It is now a
No,
closed
no,
chapter.
Close. sir.
Anyhow,
One thing, my lord, one thing.
this is essentially a question of fact.
Only one
Next.
thing. That's because you
No,
have
sir.
referred.
No,
that
nothing.
This is not my handwriting.
Sorry, sir.
Whose handwriting it is?
Sorry, sir. Can't believe it.
It is
Don't
not
say
my
so.
handwriting. Hindi. I do not-
Sir, don't try to open my more thing into that.
Then he will be more.
There is a complete finding in this regard.
Gratefully, lordship.
Molo trying for the.
Yes. Yes.
Your lordship has seen the order.
No, I have not.
Earlier it was.
Forgotten.
One kindly come to the order in question. I am just. I am reading the order.
Oh, I find certain judgments here.
The review petition.
Who is for the other side?
We have served, they are not appearing. In the earlier application also, they have not appeared.
So they are they never appeared. I find from the record that they never appeared.
Never appeared.
Anyhow,
In respect for promotion,
where is the impugned order?
placing the order. Or my lord will see.
This is of 17 June 2016. Just 1 minute. Yes, sir.
Submission before lordship.
Can you use the audio system?
My first submission before your lordship.
Is on.
Yes. My first submission, audible? First submission before your lordship. The honorable court recorded the petition is aggrieved by the fact that he was not served a copy of the original application and contents that it was necessary to move the tribunal in consonance with the Administrative Tribunals Act and the rules framed thereunder. There are no other rules. There are no rules, separate rules to move the, because L. Chandrakumar's case declared the law saying, I can come against the decision of the tribunal at any point of time.
I could not get it. Can you repeat?
L. Chandrakumar's case decided the issue, saying that against any decision of the tribunal, I can come before this Honorable High Court.
No difficulty.
I came. Now, some court said that it was necessary to move the tribunal. I have to go to the tribunal again.
No, probably,
not correct.
probably please correct me, because my understanding, which I do not know the facts,
I
to be
know.
very frank. You will tell us the fact.
Yes.
But upon reading of this observations, which is recorded in the impugned order, it appears to me on reading that the grievance of your client was that though he was arraigned as a party in the tribunal, but he was never served with the copy of the original application. And therefore, the order is passed ex parte. He came up. So the court says that you can go there before the tribunal, raise an issue that you have decided without serving a copy upon me, and then you recall your order. I believe so. That may be a intention behind it. Now, cannot anybody approach?
Correct law will be, I can come in appeal against an ex parte order, or I can go under order 913.
Correct. But the distinction, you can launch both the proceedings simultaneously. There is no difficulty.
Yes.
Even you can launch both the proceedings simultaneously.
Yes.
You can file a order 9 rule 13 there also. You can file an appeal here also.
Yeah.
But the difficulty would be under the provision of the Code of Civil Procedure. If the appeal is dismissed, then order 9 rule 13 will go. But if the appeal is not pursued, then order 9 rule 13 you can approach.
Yes.
Now, what the court says is, in that event, I tell you, suppose if it is not, then also on the basis of whatever the averments which is made in the original application or what appears from the record, you have to demonstrate that this records and this pleading just does not justify the ultimate order passed by the tribunal. You cannot bring the new fact by way of a writ petition herein. In an appeal also against the ex parte decree, that's the law. You have to restrict on the basis of the plaint, on the basis of the evidence, and then you can say that this judgment, ex parte judgment may not have come because they have not proved it.
In respect of main matter, in respect of review matter, parameters.
No, that is what I was just contemplating.
Parameter, no, with regard to my lord, order 47, the parameters of order 47 may not be applied in this case, in as much as court has inherent, High Court has inherent power.
That's true. It is ingrained, inherent into the High Court. Old judgment.
1963.
Yes, old judgment.
1963, Your Lordship knows that
No difference.
that particular judgment, that judgment 1963 Supreme Court 1909, that judgment I have brought before Your Lordship, because my Lord knows that judgment, but knows all the judgment. Still, I have brought that particular judgment.
I also forgot that. 61.
That is, my Lord.
I think few days,
Chief
that is a
Justice
61 Supreme Court.
My Lord, Your Lordship. 5 judges judgment. And
61
subsequently,
Supreme
this
Court.
judgment also was followed
Shivdeo
by
Singh.
63.
61, I believe.
See, in 1963, Supreme Court said, 5 judges bench, that court, 226 court inherits inherent power.
No difficulty. We are not
my-
disputing it.
My submission before Your Lordship, if this statement is made by the learned lawyer, that I have got other remedy, court cannot be particular authority that I will not consider law. Court has to consider the law. Whatever submission I may before Your Lordship, Your Lordship has to consider the law. Law does not provide me to go to the tribunal again. I can come strictly before this honorable court. Why the learned judges said, do you go to the tribunal? And why that statement, if at all made, I think Your Lordship remember that earlier judgment, 1982 Supreme Court, the statement.
State of
which we made,
Maharashtra versus
Maharashtra,
Ramdas Srinivas Nayak.
that I have brought I have also given some other judgments which have been followed and relied on such and such. That is the basic judgment of 1980, my lord. So, the necessary to move the tribunal in consonance with Administrative Tribunals Act. What consonance with Administrative Tribunal? Kindly see Administrative Tribunal Act. There is no provision, only review. I may not go to the review rule, not in the section. Kindly see, not in the section, but in the rule.
Hey.
Rule, kindly see rule
Arey babu,
17. My lord knows that.
দাও এরকম কেউ
In the act,
রাখে
it is
কেউ
not there. I am giving it a loss. Kindly see.
No, not required.
My lord knows. My lord knows. My lord.
No. We have the copy.
No,
Don't
no,
worry.
my lord.
It is the
Spectacular
Administrative Tribunal Act.
memory. My lord has
He-
good spectacular memory. My lord, nothing. Your lordship can
No,
say
এটা আরো
any reference at any
একটা বার
point
করে
of
দাও।
time.
এইভাবে কেউ রাখে এত মোটা আবার তুমি ঢুকিয়ে দিয়েছো ইন্ডিয়ান সাকসেশন একটা আইতে থাকবে yes section
My lord, kindly see the rule. In the act, there is no such provision of review. My lord, kindly consider this. But in the rule, it has been said in Rule 17, no application for review shall be entertained unless it is filed within 30 days from the date of receipt for the copy of the order sought to be reviewed. Not that I have to go for review first before the tribunal. That is not the law.
no that power is there section 22
Kindly see. A
section
review petition
22
shall ordinarily be heard by
Mr. Bhattacharya, you will find it because you say there is no provision in the statute. No,
No,
it is
no.
there. Section 22, subsection
Section
3,
22.
F, clause F.
Section 22. Not
Section 22, subsection 3, clause F.
Reviewing its decision.
Yes, so the power of review,
Court of tribunal reviewing its
Review.
decision.
correct. That means power of review is there. Power of review,
But not that I have to go to the review.
that is a different issue. You said in the act there is no power. In the rules there is a power. I said no, act is there.
Act is there, my submission.
And then
Lordship, I-
rule says that how the application for review has to be taken out. Rule you were reading,
That is the procedural part.
correct,
Okay.
correct.
But so far, statutory purpose is concerned, reviewing it decision.
The power of review is there in the other tribunal.
Power is vested there, but
Yes.
does not mean then I am bound to go to the review.
No.
So, the learned judge accepted particular statement of my lawyer.
Where is a provision for review?
He
Means rules.
accept
Rules.
Rule 17. No applicant for review shall be entertained unless it is filed within 30 days. Limitation. By circulation like Supreme Court. Kindly see, my lord, not our High Court, was the Supreme Court. This is a procedure.
Yes.
My submission, second submission before your lordship. Learned just said the present application is not maintainable. How? Judges said petition is not maintainable, is dismissed. How? Can't you see L. Chandrakumar's case? I brought the judgment. Can't you see all from L. Chandrakumar's case? Our learned just said it is not maintainable. My lord knows this L. Chandrakumar paragraph 95. My lord knows still in my paragraph 99.
It's mental, but I refuse to exercise. I will not entertain this. Yes.
My lord knows paragraph 99 of L. Chandrakumar. My lord knows. Your lordship is aware of paragraph 99 of L. Chandrakumar's case. I
If you are conscious,
not disturbing.
it says that the tribunal shall act as a court of a first instance
one has to approach the tribunal first. Since the powers of the High Court under Article 226 or 227 or of the Supreme Court under Article 32 are the basic structure of the Constitution, which cannot be taken away by an legislative, the fiat, or by enacting a law that cannot be done. L. Kumar is very clear, and then says that since what I feel is that since it is a substitution of the single bench of the High Court, so that's why the L. Kumar says that you can approach the division bench. There is no difficulty. Like a intra-court appeal, you can approach the division bench from a single bench decision. So there also, not in that sense, but in more truncated manner or a distorted form, it says that you can approach the division. These are very clear. There is no judgment required.
How Harish just can say.
Anyhow, the difficulty is
It is done.
matter relates to service.
Yes, we have served.
You have been, no.
This is in respect of subject matter. Subject matter that I was upon.
No, it's a service related or something. Disciplinary proceeding, order of termination or what? Discipline, promotion. That's only subject. That's. Order.
Part of the order.
The High Court's order. What is your statement in the petition?
Oh, yes, petition. Paragraph 10 of the read petition, of the read petition.
Review petition.
No, read petition, review petition.
No. You kindly consider you are reviewing an order of 17/6/2016. Third paragraph of that order records your concession. Regarding that, what is your statement in the application? I just wanted to know.
Petitioner is aggrieved by the fact. Petitioner is aggrieved by the fact that he was not served with a copy of the original.
No, that is the difference. Second line. And then
It was-
contents.
And contents that it was
This
necessary.
you says that you never said that. Where is your averment regarding this in your review application?
Paragraph 29 capital A. Paragraph 29 capital A. Page 23. Bottom.
29 is a different thing. 29A. Oh.
Ground number one also. Ground number one also.
Where is a verification? You have not verified the petition. There is no verification. Oh, this page has. Hey,
Grounds. Only see-
এটা
see
দেখো তো
grounds-
এই পাতাটা
grounds
ঠিকই আছে, এটা 32, 30, 31 নম্বর পাতা কোথায়? দেখো তো এটা জানি না, এটা তো ফেসে রয়েছে, দেখো ধরো এটা 30, তারপর 31 নম্বর পাতা নেই, অ্যাফিডেভিট অফ সার্ভিস আছে, ছিঁড়ে বেরিয়ে গেছে নাকি?
Grounds, grounds number one.
আপনার কপিতে আছে? হ্যাঁ কি বলছেন? Verification? কিভাবে পিটিশনটা হলো? তারপর 32 দিয়েছে ওখানে, 32 দিয়েছে, তারপর সার্টিফাইড কপি 31 পাতা কোথায়? 31। হ্যাঁ সেটাই তো ভাবতে পারছি, মানে তো অ্যাফিডেভিট পোর্শনটা কোথায়? Where is an affidavit of your application?
Grounds, your lordship can see. Grounds.
No. You have filed an application for review. There are two
Grounds.
grounds. It's a memorandum has to be filed. না না, এটা মেমোরেন্ডাম, এটা মেমো নেই এখানে, আমি দেখেছি। এটা 369 কোথায় আছে? এটা 369 হচ্ছে মেমোরেন্ডাম। কারেক্ট, কিন্তু করেছি জানো। Madam, you have not filed the memorandum. It is lying with you. I do not know from where you got it. No, but it is not, it does not speak of that, because we find from the application there is a SR
The stamp reporter's note is on an application. No memorandum has been filed. Who is the filing lawyer?
No memorandum was filed.
No, it's not on record. ও এটা তো আপনার কাছে আছে হ্যাঁ ঠিকই এটাই তো দরকার এখানে নেই কিন্তু আমার কাছে
I got the copy.
No, 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 no. My brother has a copy, but so far as my
No,
file does not have.
it's not in the record. I
Huh? Oh. It is lying with my brother's file. এই তোমরা দেখো না এইভাবে সেগ্রিগেট করে দাও দুটোই চলে গেছে ওনার ফাইলে ওটা দুটোই চলে গেছে ওনার ফাইলে Madam, when an application for review is also filed, will you not affirm? There is no page of affirmation.
My copy also I do not find. In my
Nay,
copy also I do not find.
It's not there.
Can
How
you
it
see
is done, I do not know.
Page, one page is missing.
It's not there.
34, 31 টা কোথায়? হ্যাঁ, এখানে paragraph এই তো। Page 30 আছে তো? 32 আছে। 31 টা কোথায়? Connection. Okay. Page টা কোথায়? Page 31 is missing. That one is missing.
My copy, my brother's copy,
Yes, yes.
your copy, everybody's copy.
কি করে বলবে? Although he also kindly on grounds, in the grounds I have taken the ground. Kindly see ground number 1, I have taken.
No, Mr. Bhattacharya, one has to look at that how this particular paragraph or the statement is construed or have been affirmed by you. If you say the submissions, then we will not record. If you say the true to your knowledge, then we can definitely go by that.
Cannot even. Then I had to be affirmed.
And who was the advocate who argued?
Trial court. Oh. Mr. Dinendra Chatterjee. Dinendra Chatterjee.
I didn't notice on the earlier occasion, but there is one judgment which is staring at my face of the Supreme Court. That changing a lawyer, filing an appeal, no. We will not.
The earlier case, your lordship.
We will not.
Oh,
Will not.
your lordship.
We will not accept.
Earlier judgment, your lordship.
Yes, we have referred it.
Recorded, but
Yes.
declined.
So we will not accept in this. If he comes, he has to say that he has not made the submissions. Mere saying that I never instructed will not do. He has to come that I did not make any submission. Then I will believe. You'll have to give a notice, otherwise we will not. That case of the Supreme Court was very ugly.
My submission, people, he was not instructed to make the submission.
So he has to come and say, yes, either he has to say I make the submissions, but there was no instruction, or he has to say I never made submission. Two things he will say. Let him say either of two.
Yes.
Yes, call the next.
I take
Let this matter be spilled over after vacation. Next is the 19th, cannot be done.
your side fine.
Item number 15, my lord, I am led by Ms. Susmita Shah Datta. My lord, this is a change brief, my lord, and I produce the court record, my lord, the abbreviation of the court officer, my lord. There is a dispute, my lord, that, my lord, there is 884 days delay, my lord.
Okay. অনির্বাণকে বলেছিলাম AIR 1997 সুপ্রিম কোর্ট 1009 বলেছিল, ওটা 1005 অনির্বাণকে। AIR 1997 সুপ্রিম কোর্ট, ওটা আমি বলেছি ওকে 1009, ওটা ভুল, এটা 1005 হবে। Service.
My lord, I have served the notice, my lord, but I failed to make the affidavit of service, my lord.
The service is not complete. Let the matter be listed after vacation.
My lord, there is a delay of 884 days, my lord. That application has not been filed, my lord, by the earlier
I
advocate.
do not want to.
Kindly, there is a order, my lord, to file.
No, we will not give you order. If
Okay,
there
my
is a delay, you will have to take care of it.
My lord,
I will grant you a time.
my lord, deeply obliged.
Yes, call.
Similar time for the petition.
Oh, Mr. D.N. Chatterjee is here. Oh, D.N. So, he is here. Sorry. What is this contempt?
There is a restoration application pending, my lord.
That is already restored.
My lord, two restoration applications were filed. One was, my lord, originally
Oh, restoration of Can 1.
Can 1. That was, my lord, allowed.
Can 1 is restored.
Restored.
Now, what is this Can 1?
My lord, the Can 1207 of 2019 is pending. That can is pending.
I am asking you, sir. Can 1 is Can 12087 of 2019. What is that application? I am asking you.
Restoration.
This is also restoration application. Where?
Restoration of the restoration of.
This is what is really happening now at the bar. Dismiss for default on 13/11. 13/11/2019.
2019.
It was dismissed for default. Writ petition.
Contempt applications. Yes.
Oh, sorry. Contempt application was dismissed for default. Yes. What is this COST? That is the parent application.
Parent application is well as COST.
Passed by the tribunal.
Against the order passed by the tribunal, the COST was prepared.
Yes. You are opposing seriously.
May I cut short the matter? It's a contempt application. For alleged violation of the order passed by the Hon'ble court.
Yes.
The state government. We have given all benefits according to the order of the Hon'ble court. Then we sent it because there were the three cadres in 1992. West Bengal Medical Education Service, West Bengal Health Service, and West Bengal Medical Administrative Service. There was a dispute. Ultimately decided by the Supreme Court. Act was granted. He was given the benefit according to the order of the Hon'ble court. Then he was allowed, fixation was made. Then he filed an application for pension. Retirement given effect from, according to the pension application, effect from 1st October 1996. We are writing letter to the time once and again. Some payment has been made.
Could not get it. What is it?
One after another, we have paid some amount.
Yes.
But ultimately refixation has to be made because another fresh PPO has to be issued. We sent it to the AG Bengal.
Further refixation, I understand, has to be done.
After refixation, we sent to the AG Bengal.
Okay.
AG Bengal, my lord, we are not getting any reply. Last letter was issued on 11th of May 2023. Reminder that we are facing contempt proceedings. Kindly return the file or approve it. And let my land friend go to the department.
Now AG Bengal, you are the additional government leader. Don't you exercise your?
No, but AG Bengal is the Controller and Auditor General of India. There's the central, they are under the central government, under the constitution. Because all expenditure to be audited by the.
I understand, I know.
Because it is a consolidated fund of the state.
My lord, this is the second round of contempt. Lordship kindly comes to my lord page 70 for the first round.
What happened?
I've given an assurance before the court that order was to be complied with.
In 2014.
14.
So till date, the file has not been, the file is not returned. Unbelievable.
Can you see the letter?
Inconceivable.
2010, 2010, 2011, 2011, 2021.
The employees in AG Bengal, their salaries are, or they are the employee of the central government or the
Central government.
They are getting what the salaries is admissible to a central government employee. I do not think so. The Auditor General office is completely different, independent.
No.
Autonomous.
No. They are under the control of a Controller General, Auditor General of India. Now they will submit a report before the Parliament, and Parliament will approve it, submit it to the President. Whatever the expenditure we incurred on the consolidated fund of the state.
Whether
We
they
are
are party here.
Well, there was no scope. There was no scope, my lord, to make the contender, my lord, was made a party, my lord. The AG Bengal of the office of the AG Auditor General of Bengal, my lord, that cannot be. There was no scope.
Because he says that that is required and he has already sent the file. I mean the service book.
My lord.
That has not been returned.
My lord.
In spite of 10 reminders.
Lordship would be pleased to grant a leave, lordship. We can add them as a party, my lord.
How can in a contempt?
Lordship, that is the difficulty, lordship, because the contempt, lordship, originates from the application itself.
And initially that Dr. Shukla was the secretary. Now Dr. Shukla has reported to the central government as the secretary of the department. But we have tried on level base to expedite the matter so that the person should not suffer. If he is in difficulty, his son or daughter can go to the office with the person concerned. I'm giving his address.
Where is the Deputy Solicitor General? Call him.
My lord. My lord, I'll do it.
We can expedite from here.
My lord. Lordship would be pleased to lordship fix a date and express lordship's opinion. Which we can
Please
say.
call him.
Right.
Don't you know?
Lordship.
Tell him to come.
I'll do it.
We are here. Tell him to come.
Lordship.
My lord, in this matter, my lord, I am appearing for the 17 to be covered. 17 that. Can I go? সাপ্লিমেন্টারি এফিডেভিট করেছি, কন্টেম করেছি, এফিডেভিট অফ সার্ভিস করেছি।
Supplementary affidavit has not been filed.
Yes, my lord, it has been filed. last occasion, your lordship directed me to serve. And also serve upon the contender, my lord. My lord, this is my affidavit of service. Sir. They have received. কি পানি সেটা দেখুন ওখানে সাপ্লিমেন্টারি এখানে আছে কল্যাণ দাসের ব্রিফ দিস নি ওখানে কন্টেন্টটা
So what is the, we directed that the application for compassionate appointment
yes
has to be done in terms of the order dated 17th August 2021.
that order also annexed with my content application earlier.
WPST 89. Where is that order?
The earlier order, just before that.
In a content.
The page is, my lord, I'm giving the page 17 of my contempt application. আপনাকে একটা কপি দেবো এখন দেবেন
The direction was passed that proceed on the basis of the 2008 circular.
Yes, my lord, after the verification and
From
my lord, the
state
interview
After the interview.
and the verification. My lord, they have taken now the point, earlier occasion, my lord, they have rejected, your lordship directed on the, this is the second round of litigation before this honorable court. My lord, they have again rejected my claim on the basis of that at the time of death of my father, I was minor. This point has been taken earlier. This court rejected their claim because in spite of I am minor, my lord, they are called me in 2010 for the purpose of interview and physical verification. So they, my lord, this honorable court directed that you waive this minority ground
No, no.
and my lord,
Have they gone contrary to this? Because the court
Yes, ma'am.
was very clear, 2008 circular.
yes,
Have
my lord,
they,
your
have
lordship
they
kindly,
taken
your
recourse
lordship
to
kindly,
2008 circular?
yes, my lord, your lordship kindly come to the my lord, supplementary affidavit where I have, after the filing of contempt application, they have served me the order of this order as per your lordship's direction. My lord, that was, my lord, I have already annexed here. My lord, that is a photocopy of their earlier order, which has been, my lord, set aside by this honorable court. Twice, my lord. Annexure P4, that is page 5.
As laid down in paragraph 2(1)(I). Where is that 2(1)(I)? Where it is quoted?
Your lordship kindly come to the first page. It is to reveal the following. These are their findings. Now, as per 2008, my lord, this following the findings, which is in my favor. They have recommended, the inquiry committee recommended my name.
No, I do not know what he is given. You were given an opportunity of hearing.
Now, the hearing, they have, my learned brother went there. They did not want to hear anything. And my lord, simpliciter, my lord, passed this order. Your lordship, may I, my lord, place your lordship's order first, then my lord, the order of this, my lord, the authority, additional chief secretary.
দেখো এভিডেন্স সাইজ দেখো তোমাদের এখানে চাও তোমাকে সাথে কপি সব দিচ্ছি তুমি যদি অ্যাপ্লাই করো বলে হ্যাঁ 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 এক্সট্রা আছে সাপ্লিমেন্টারি এভিডেভিট আর কন্টেম্পটেড কন্টেম্পটেড কপি আছে একটাও নেই? একটাই কপি দাদা তোমার কি কপি দেবো একটা তার নাম্বারটা বসে
Now, what is left after the interview? What is left after the interview? Nothing.
Nothing, my lord. That's my, my lord, the point before this honorable court earlier occasion and as well as before your lordship. Your lordship asked them that you have already waived these provisions and my lord, you called the petitioner for the interview and for physical verification. Both are complied with. Only the question of my lord, issuing the appointment letter. On that score, now they have my lord, denied. And on 2018, after 2010, Malad, 2018, they issued that you should not be given any appointment letter. As per 2013.
Yes, Mr. Mukherjee. Because that was the same decision was challenged before us in the writ petition. Saying that since they could survive more than 7 years, so there is no immediate financial assistance required. We set aside the order. Can you take the same ground again in the yes? What are you
Affidavit of
saying?
service
It has
before your
been
lordship.
served. It is served upon you,
Service
and
to-
it appears that you have taken a same plea. No, वो तो affidavit of service. You have taken a same plea.
Passed by the additional chief secretary. The order has been passed by your lordship, so that you can challenge the order before the learned tribunal.
My lord, again I shall go before the learned tribunal. Again, my lord, I have
We
came back
will
before this
call
honorable
them
court.
to appear.
My lord, this is the
If
third
they,
time.
if
they-
they want to do it in this fashion, then we should call them. The same ground is given.
Can you do one thing? Can you give us short election for affidavit?
No affidavits are required. It's a per se apparent, the contentious act. Why you should be given an opportunity to file reply?
So that I can take instruction from the department.
What is the instruction? The instruction is reflective of this decision.
Already looking at.
This decision you have already taken.
25th March 2022.
Yes, no, not 2022, 6 March 2023. You have taken a decision, same ground,
Page 5, দেখো না, supplementary page 5.
same ground. And you wanted to, in other words, say that the earlier division bench, that's the coordinate division bench, was wrong. That is an audacity that has been shown.
Let me talk to the.
What do you have said there? The division bench has observed something and then you say that you are wrong.
Certainly not.
That is what is there.
But that's why we'll give it but some time so that I can talk to the department and.
This cannot be done. That's an apparent example of it.
I may talk to the home department because.
And when the contempt application, when the notices have been served, then you come with the order.
Yes, ma'am.
When it is communicated,
My lord, the communicated on my lord, date টা দেখো। After filing of contempt application, after passing of your lordship first order, my lord, this has been communicated to. Probably.
Final plan
Kবে,
is charged
kবে?
the order before the landed.
The contempt file করার পর হয়েছিল, তাহলে
Apart from the what the decisions have been taken compared.
নোটিশটা
let the supplementary affidavit filed today be kept on record. In the said supplementary affidavit, the petitioner has enclosed the order dated 6 March 2023 passed by the additional Chief Secretary, Home and Hill Affairs Department, disposing of an application seeking compassionate appointment. So it prima facie appears that the ground for rejection, which was taken in an earlier, which was taken earlier and was set aside, has also been taken in the said order. Essentially, the same ground is repleted and therefore we think we find a justification in the stand of the petitioner that it may tantamount to contemptuous act. Full stop. Furthermore, we find that the said order is passed after the contempt application was entertained and a direction for filing was taken up after the contempt application was filed before this court.
The order was passed by the additional chief secretary, not by the others contempt.
Sir, I have recorded that, sir. Additional, it has been passed by,
Additional chief secretary.
yes.
My lord, when your lordship first directed the matter to the special secretary, that's why my lord, when the contempt application has filed, my lord, we know that the special secretary.
No, 6 March order is passed by the
Yes, my lord.
Additional chief secretary.
by the additional chief secretary.
And my lord, our my lord, contempt application is before that.
That is what I am saying.
Yes, ma'am.
The
My learned
subsequent
friend-
order is a 25th March 2022 is not a subsequent earlier order which was set aside.
Yes, ma'am.
Until
So-
the order has been set aside by.
Correct. So what we have done, same thing. কি বলো? কি বলেছি? Before this court. And therefore, an explanation in this regard is also required from the alleged contemner.
That is going to pass this order. Order has been passed by the additional chief secretary.
Oh, we further notice that the said additional chief secretary, Hill and কি আছে? Huh? Home and Hill Affairs Department has not been arraigned as a party, though the direction was passed in the writ petition to dispose of the said application. Therefore, we permit the petitioner to add him a party as respondent herein. Let the affidavit. Now, since Mr. Mukherjee is appearing, since Mr. Mukherjee, Tapan Kumar Mukherjee koro, who holds the post of the additional government pleader and appearing for the LS contender number 1 and 2, we do not find any difficulty in appearing for the added contender as well. Since the copy of the contempt application has been served upon Mr. Mukherjee, we direct the contemners to file affidavit within 1 week after the reopening of this court following summer vacation to the contempt application as well as supplementary affidavit. Reply, if any, shall be filed within 1 week thereafter. The contempt application is made returnable 3 weeks after the summer vacation.
May I be supplied the name of the additional chief?
Gopalika, Mr. Gopalika.
You can elaborate. Why Gopalika?
Sir, my lord, with respect to 15, item number 15, my lord, 15, my lord, I went, my lord, to the office of the learned ASG, my lord. He has left for the day, my lord.
I said Deputy Solicitor General. I know ASG has left for the day, but Deputy, because he normally, he requests not to keep any matter after 2.
My lord, my lord.
I said Deputy Solicitor General. I never said ESG.
My lord,
Yes.
And for the petitioner applicant, my lord. My lord, on the last occasion, my lord, pursuant to your lordship's order
Forwarded all the.
to applications.
What is this CPN, madam?
My
Have you
lord,
served the copy?
yes, my lord, they have served me a copy, my lord.
You are for the LS contender?
No, my lord, I am for the petitioner applicant.
So they have served you a copy. That's why I just asked.
Copy of the, my lord, extension for comply with the order, with my lord's order.
Why you want an extension?
Matter for the respondent.
Why you are?
Just for consideration.
My lord,
Because he, it's a dispute proceeding, he filed a new petition.
my lord, yeah.
Filed, then PSC said, no, you should have to dispose of the legal petition. Then we have considered that you have dispose of. Then again, we have found out the officer description. Now, petitioner for reply from the PSC. Now for the PSC to dispose of, as soon as the
No, service.
My lord, kindly cease.
Another.
Is a state service commission or the school service commission?
Public Service Commission.
Public service commission. So public service commission, you have moved.
Yes.
They have not given you a reply. Who wanted to review?
There is no case pending against the petitioner.
Why? Under what provision to case consider?
Wrong submission. My lord, may I submit, my lord?
Let me understand first. Now, are you not understanding that state and the
That is
service
why
commissions, they are
I'm troubling your
just
lordship.
passing the bugs?
That is
So
why I'm
just, I
troubling.
understand. Let me first ascertain, then
I
we'll
know.
hear you.
I know.
And you are merely an informant to the court in a contempt jurisdiction. You have no special right in that. It's a matter between a contemner and the court. So let me ascertain first.
We have followed the reports on the 10th May 2020.
What was the hurdle in not giving him a client a promotion? Correct.
Punishment was there.
What punishment? No difficulty.
Then he filed an application for revision before the government.
They filed.
He filed.
Correct. So government,
They but in the meantime, they wrote that 1 year has passed because you can consider. Therefore, we have followed the paper to the Public Service Commission. Public Service Commission asked for certain document.
no, I could not get it, sir. First thing is disciplinary proceeding was there, which culminated into an order of 2 increments in 1 year.
Sincere.
Censure, then nothing.
Filed a review.
You filed.
No, he filed a review application before the government.
No, no, my lord. There is no disciplinary proceeding against the petitioner, my lord. The disciplinary proceeding was against the the respondent number 5 in the writ petition. And my lord, the first.
Kindly
I'm
consider there are
submitting.
2 petitions stacked. 18 and 19. I appear in item 19 for the respondent, but who was also the respondent in the first item, that is 18. Now, my lord, he is a candidate, aspirant candidate for the promotion to the post of DIG. He suffered a punishment of censure and a period of 1 year.
And what about her client?
My lord, I am also interested in the same post, in the same promotional post. My lord, 3.
What punishment you suffered?
I have not suffered any
There was no,
punishment. There was no, that is neither here nor there. I was no way suffering any kind of punishment following any disciplinary proceeding, my lord. My lord, may I kindly submit, my lord?
What?
My lord, what?
I think
what my,
all of you have jumbled the fact in such a form.
may I please the
Till
fact,
this
my lord.
time, I am unable to make a link or comprehend.
May I submit? my lord?
Better, all of you, please stay away for the time being. Let me first read my order or our order which we pass. We will get some link from there. Please, then give us. All started at the same time. We passed an order on 16/9.
Yes, 2022.
This is an order which is complained of that it has been violated.
Yes.
In the contempt petition.
Yes, just.
Now I got a clarity. I got a clarity. Who is appearing for this Devasis?
I am.
You are appearing. So this Devasis was a candidate, he creates a problem. Because there was a disciplinary proceeding that was contemplated. There was a penalty of censure. Then for a deputy inspector general post of under the correctional, his name was to be considered. He wanted. The state government, they imposed a condition that 1 year, because the censure have been given for 1 year, you will not your candidature will not be considered. PSC, they said no, this is more harsh, that cannot be done, revert it back, you consider. Now the question arose that once they have, whether they have an authority to supersede the order of the government, conscious decision of the government. They are simpliciter or recommending authority. Our judgment was that they cannot impose something on the government. They are simpliciter or recommending authority. They cannot do it. Now the government stand was, now in the meantime 1 year has expired. But there was an interim order passed in the proceeding where it was they were restrained not to fill up that post. Now 1 year has gone. Now they have to fill up the post. There is no impediment. We have said that all eligible candidates, including you, to be also considered. Right. So now what is the hurdle? Why they are not considering? Why the contempt has come? Now you tell me, madam. Why the contempt has come, sir?
My lord, may I read the last portion, the operative portion of my lord's order?
Yes, please.
At the cost of
Please.
repetition, my lord. Lord, the appropriate authority is directed to proceed with the filling up of the said promotional post
Yes.
in accordance with the procedures applicable in this regard
Correct.
and shall permit all the
They
eligible
are saying all eligible candidates.
Yes, my lord.
Who says no?
That is why, my lord, may I just
Yes.
repeat this? including the applicants, if otherwise not entitled to by any reason.
Because of the reason, because they were contemplating something more. Suppose another disciplinary proceeding is initiated against you. You don't know this employer.
Now, my lord, apropos this.
So we said that if there is, or a matter has gone up, if there is further restraint order that has come, or somebody else have gone there to the tribunal and then obtained an order of injunction not to fill up the post. That is why we were conscious. Now I understand why we recorded it. That if there is no interdict, then you'll have to. If there is an interdict, then at least you will not be held guilty for contempt.
My lord, apropos this, now, my lord,
Suppose
consider.
you two have come, third candidate may also be there. He has approached that my candidatures are not considered. And the interim order is passed not to fill up the promotional post. What is the fault?
Lord,
You will
let-
come then see the division bench order
Let them show that there is any
is
such
what
order.
all eligible candidates, let us ask him whether what he is doing regarding this.
That is what my lord, may I kindly submit, my lord, that
Yes.
is what I'm submitting, my lord. Apropos this, my lord, kindly consider what my senior has submitted, my lord, that a review has been preferred from a punishment order, my lord. My lord, I say, my lord, this is a